My lords, kindly, my lord, serial number 28, my lord.
28.
28, please, my lord.
Yes.
My lord, I appear for the appellant in this matter. My lord, arguing counsel had to undertake travel on an urgent basis today. I request for a short date, please, my lord.
Twenty-first April.
Obliged, my lord.
Serial number.
My lord,
Obliged.
serial number 54.
Appeal, my lord, one memo fresh matter. These objections are being complied. Lord, rent revenue matter, please, my lord, where I made a representation to remove the encroachment in the pathway, which is belong to a Pakka road, please, my lord, which is in the village map. It is being encroached by a, my lord, landowner.
What is the urgency?
Please, my lord.
What is the urgency?
I'm able to access, my lord, my property. That is the reason.
25th March. Yes. Mr.
Pertains to pre-match matter. Even though there is a report by the district environmental officer, there is a pollution, the respondent number, private respondents are running the sawmill in the residential area.
No urgency. 1st April.
Your lordship leave in the contempt matter and for the complainant, despite clear order of the learned single judge, the accused is proceeding with the construction. The previous week, in the first hearing, they have taken.
28th March.
Serial number
27.
27. 27.
27. Yes.
Who is not keeping well. 27.
Pardon?
My senior counsel is not keeping well.
Senior is not keeping. We'll go to 9th April.
Serial number 36, my lord. Serial number 89, my lords. We have informed other side counsel also, my lords.
89. So, what do you want?
It's connected matters, my lord. We have informed other side counsel also, my lords.
You are for whom?
We are for, my lords, in the second matter, we are for applying.
Here?
In the first matter, my lords, there are two connected matters, my lords, 89.1 and 89. In the first matter, my lords, we are respondent. 89.1, my lords, we are for the appellants. But we also informed the other side also. After 2 weeks, all, my lord, next week, any date may be fixed.
There is no urgency. Let it go after summer vacation.
After 2 weeks, my lords, any date.
After 2 weeks, any date.
Yes.
16th of April.
Please.
So an interim relief is operating.
Yes.
It is limited.
Interim order is there.
It is limited or not limited? Not limited.
Please.
Not serial number 54.
Office objections to be removed in 89.1.
Yes, yes.
Before the next date, the office shall be removed by
Please,
the
please.
party concerned.
Not serial number 54, my lord.
Pensionary benefits are required to be settled.
Pensionary benefits.
That's my request.
16th April.
Just kind permission.
Senior citizen, my lord. Pension, he is a senior citizen. Pensionary benefits are required to be settled as per the order of the.
16th April.
My lord,
16th April.
serial number 54, my lord. The
50.
contempt matter. The
54.
accused has issued the endorsement saying that, my lord, it has to become to drop, my lord, because the endorsement has been issued. So 54.
So you are for respondent.
Yes, my lord.
Endorsement is
Liberty
issued.
to the challenge before the appropriate court.
Where is the petitioner?
I'm for the petitioner. I'm
So
for
you
the
are saying that it is endorsed. Learned advocate Miss,
54.
what is the good name?
Manjula VA.
For Madhusudan M.
Please.
Stated that the order under contempt is complied with as the competent authority issued endorsement.
Yes.
Full stop. In view of the statement, the present contempt petition is disposed of. Full stop. It was requested to the court that liberty may be reserved, paragraph, for the petitioner complainant to challenge the endorsement on merits.
Yes.
If so, advised. Full stop. Such liberty is reserved. However, in that regard, the court does not express any opinion on merits.
My lord.
Thank you.
Permission.
Please.
My lord, one
My lord, it's a public interest litigation matter, my lord. Last time it has come and certain small objections were that has been complied. In this matter, date is being given on 2nd of April, my lord. There is some urgency. Construction is going on CS side, civic amenities side. It's
File IA. Once date is given, no preponement by memo. File IA. if there is a serious urgency. Yes.
Permission.
Serial number
Secondly,
36.
Serial number 81.
81.
Service is not complete, my lords. I paid the process on 6th March. This notice is issued only on 14th March. A short date may be given, my lords, please.
It is PIL.
Yeah, please, my lords. I paid the process on 6th March, but
Your
notice
Honor,
is issued only on
For the
14th.
petition
A short
stated
date,
that the process pay is paid, however, the service of notice is awaited. In that we put upon 3rd April,
please, my lords.
3rd April.
Serial number 36, my lordship.
36. What do you
Yes.
want?
For petitioner, my lordship, senior has undergone small surgery. 2 weeks
All
time.
surgery. 36. So it will go after summer holidays.
Please, my lordship.
And as requested, on the ground that the learned senior advocate who is to conduct the petition has undergone surgery, stand over to 11th June, 12th June.
Please, my lord.
Lordship's permission. Madam, my lord, the appellant was working as a Dalayat in the legislative secretariat. He was working as a Dalayat, my lord. For the learned single judge, my lord, without making him a party, an order has been obtained behind their back, my lord. And the Honorable learned single judge, my lord, has asked the entire list to be redone, my lord. During the pendency of the defension, a memo was filed stating as to the candidates who would go out of the list, my lord. The appellant's name is evident there, my lord. My lord, without hearing me, my lord, without making me a party, my lord.
What do you want?
My lord, I had to be posted tomorrow.
No urgency.
My lord, there's urgency. They
What
will
is the
relieve-
urgency?
They will relieve me on 21st, my lord. They will relieve me, my lord. I will be out of job. Any day, my lord, tomorrow, day after, my lord.
Day after.
Please, my lord.
Yes, madam.
That's a fresh contempt matter, my lords. The single judge has set aside the body and duress, my lords. The complainant, my lords, has filed an application. The accused, my lords, are redialing, my lords, to consider, my lords, the application any day.
7th April.
My lord, serial number 73.
Serial number
73.
70.
As the senior sister has died. Car accident.
Pardon?
In a car accident. The senior sister has died in a car accident, sir. Kindly pray.
Who died?
My seniors.
Senior?
Senior sister, Lord.
Uh-huh.
So kindly
So,
pray to us.
Pencil 73. After summer holidays. What is it about? PIL of 21. All right. 1st April.
Your Lordships, 2024 contempt matter, Your Lordships, writ petition and writ appeal says that I am to be not terminated from my service, but it has not been posted even once before this honorable court, Your Lordships. And I am at the risk of being terminated from my service.
Serial number?
Memo, Your Lordships.
What is the urgency?
The urgency is that I will be terminated from my job. I am being terminated, 2024.
27th of March.
Serial number 18, my lord. I am for the contesting caveat respondent.
18.
Please, my lord. And the entire set has not been served on me. I have to file objections to that, my lord.
To other side is no objection.
Yes, my lord. I have informed the appellant side.
So which date do you want?
Any date, my
No
lord.
objection.
Appellant side is also present, my lord.
So let it go after the summer
Vacation.
holidays. 13th of June,
Much obliged.
Serial number 70, my lord.
as requested by both the sides.
Serial number 30, my lord.
Yes, Mr.
Serial number 70, my lord.
This PIL lordship in this, the land preserved for the tank area has been used wrongfully by the private individuals. The matter may be
No
posted
urgency.
after a
Let
week.
it come on 24th April.
Contempt petition for the complaint.
Obliged.
There is a direction to the BBMP to register the Kata Malad. The contempt of the year 2023. Any date may be fixed for a hearing. Malad. Study notice. Malad. There is a stage.
Date must have been fixed.
Any date may be fixed. Malad.
Date must have been given.
No, my lord. There is no date is fixed in this matter, my lord. There is a
Just
clear
wait.
direction to the.
If there is no date given, then 8th of April. If date is given, don't accept the memo. If date is given, it will be rejected.
23.
Mr. Counsel,
Please, my lord.
if the date is already given,
Please.
this will be rejected. You have to file IA.
Please.
23.
My lord, say,
Fixed.
Complainant. 6 weeks time ago, senior is posted one Harvard High Court. There is a two.
Any urgency, then it will go to
This is the second contempt.
22nd of April.
My lordship.
My lord. Serial number 30.
30.
I am for the appellant in this matter. Inconvenience, my lord, kindly have a turn. Speak, my lord. Some inconvenience, my lord, kindly have a turn. Speak.
Beyond then, it will go to 16th of June, as requested by learned appellant on the ground of personal difficulty. Yes.
Lord, there's a 2022 PIL, my lord. I'm for the respondent, my lord. My lord, the petitioners have sought for mentioning the matter.
22 is not PIL.
No, my lord. The memo I'm moving is of the year 2022, my lord. It's a PIL, my lord. I'm for the respondent, my lord. The petitioners have sought for demolition of the petitioners of the respondent's property, stating that it's on the government land, my lord. The matter of the year 2022, my lord. Hence, I'm moving this matter before your lord. The pleadings are complete.
What is the urgency? After 2 years.
My lord, I'm for the respondent, my lord. The petitioner only have been harassing the respondent, telling that the
23rd April.
My lordship, I am in the item number 59 on the VC.
59 years.
At party in person. I want to appear physically the next week on 26th or 27th of March. I'm in
learned party 59. Learned party in person. Mr. Ashok Kripalani appeared through video conferencing to submit that he wants to conduct the petition by physical appearance and
26th or 27th March.
Full stop. In view of the request, when shall we keep Mr. Party?
27th of March.
27th of March.
In the first 20 cases preferably because notice has not been issued yet.
As requested by him. Yes.
Serial number 70, my lord.
Thank you, my lordship.
Serial number 70, my lord.
17.
Connected main matter, my lord.
Serial
WA
number. Identify the serial
1492,
number. Identify the serial number first.
70, my lord.
70.
70.
What do you want?
My lord, connected matter writ appeal 1492/24, my lord. It is posted on 29/4, my lord. It may be connected along with main matter, my lord.
There is a delay of 3 days also.
Yes.
So what do you want? Time? All right. After summer vacation. 17th of June as requested.
Malords, item 80. I'm sorry, Malords.
Item
80, Malords. Your Lordship may kindly recollect this is a withdrawal of the prosecution.
As requested by learned advocate, so and so who appeared to video conference. Yes.
Your Lordship may kindly recollect this is a withdrawal of prosecution cases by the government.
Yes.
Item 80, Malords, certain cases were withdrawn prior to Malords interim order was being passed. So Malords, if your Lordships can consider some arrangement today, Malords, before end of the day, if a matter can be taken up. Because virtually if the applications are filed in every case and 5 cases are permitted to be closed.
All right. We'll take up at 88. You come physically better.
I'll do that, Malords. I'll do that.
So in this second half.
Yes, Malord. Yes, Malord. Yes, grateful.
My lord, notice hasn't been returned.
Already issued.
No, my lord, the waiting.
No, Malords, all the respondents are government agencies.
Let us see.
Grateful.
Yes. Any other mention? Contempt matter, still number 1, still K.R. Satish.
For petition, complainant petition. When they were served with the order. Yes. The respondents were served with this order on which date?
As per annexure D1. 16/12/2023. 16/2/2020. Page 24.
They were served on 16/2/20.
21 and 24.
16
Annexure B and B1. 16/2/2023.
Served. When the petition was filed, contempt petition.
12th August 20.
Then after 1 year.
They are sought for an regularization. They are working there.
I'm given to understand that we have considered the representation. Next date of hearing, I'll produce the same. We have issued an endorsement with regard to the same.
So when shall we do?
Next week, my lords, will produce the endorsement.
Next week will be 25th of March at 2:30. Since extend out to 25th of March to be listed at 2:30. Since learned additional government advocate Shekhar stated that the authorities have considered the representation of the petitioner. Notice returnable on. Complied with. Learned advocate Mr. Hegde stated that the order under contempt is complied with. In that way, nothing survives in the present contempt petition. It is disposed of accordingly. Next.
Number 3. Sharat S. Gowda.
Complainant, my lords.
They have transferred. They have transferred the property.
My lords,
Alienated the property. Anything.
there are specific directions, my lords, by the learned single
That-
judge, my lords.
Therefore only we are asking that they have alienated the property.
My lords, state deeds are also produced.
Notice returnable on 23rd April.
Number 4. Ranjan Kumar, the petitioner.
Lord, for respondent number 2 and 4.
Real number.
Number 5 in this matter. Copies of the petition is.
My lord,
Where is the order? Restoration of power.
Annexure A, my lord.
It is about restoration of electricity. Restoration of electricity.
Yes, your lordship.
Where is that order?
It's on 24 page number, your lordship.
Page number 24.
Annexure A, your lordship.
You are there.
Yep. I'm
Copies of the.
Correspondent.
respondent 2 and 4.
So you are supposed to restore the power.
No, we have not actually disconnected anything because they did not have in their own this one. There was an order 87/22. In that it is a conditional this one. It's a dispute between the landlord and the builder, and wherein the petitioners have basically taken the flats from the builder. Because there was a dispute.
Who is this Satish?
Satish is the complainant, your lordship.
Complainant.
Yes.
But what is the status?
Yes.
Lordship?
What is the status?
Status.
He is
Yeah,
seeking
he-
restoration.
No. He is the owner, the flat owner, your lordship.
So he is seeking restoration of power supply.
Yes, your lordship.
So do it.
My lord, there is a small issue over here. They were supposed to pay the charges relating to that, which they
You
have
are
not
ready
paid.
to pay the charges.
Yes.
No, lordship. I'll tell you the brief facts, my lordship. I purchased my property through the GPA holder, and I was in the possession. And suddenly what happened? The landlord who has got little share of it, out of 7 flats, he has got 3 flats. His Lellas came and threatened me that I'm going to disconnect the power supply. Then afterwards, I went before the local police station jurisdiction and filed a complaint. NCR was filed, your lordship. After that, I filed a injunction order not to interfere in my property. Then I got the interim order in behalf of me. And then after that, they filed 2 FIR consecutively with a fraction of 2 weeks. They filed a FIR, and afterwards I was put into jail, provided on a 307. Then after filing of the charge sheet, it was drastically reduced to 324. The one FIR was 323, the another FIR was 324. After that, I filed a writ petition for the restoration, including all the BESCOM and the respondent 5, your lordship. The court granted the interim order, your lordship, point number 4, and it has been exorbitantly heard, and whatever the contention technicalities, all it has been heard, and court has, if your lordship, point number 4, therefore the respondent number 1 to 4 are hereby forthwith directed to restore the power supply to the petitioner flat, subjected to the petitioner sharing the bill amount appropriately. So the court has directly to forthwith. But even then, I've been roaming from past 8 months to pillar and post.
Also, you are
Yes.
supposed to.
They were supposed to comply. 2 of them have complied, my lord. We have already restored. These people have not complied and we could not.
Proportionate. Bill amount, you have paid the bill proportionate.
We are paying, your lordship. We were paying, but now they are telling that the builder has to give the money. So they are trying to, because I am not sure, because I have purchased the share of the builder, your lordship. Now they are coming back.
You will be sharing the bill amount with whom?
Yes.
With whom?
With the landlords he has got the transformer in his name, and in the initial days we were in the position, we were giving a lot.
Do it and they will supply.
Yes, my lord.
You have to do it. Your part of performance is to be done by you.
The other petitions have already complied and they have already obtained the power. Only He is not at all.
Unless you perform your part, where is the question of?
My lord, in the same thing, others too have already complied. They have obtained the power. They have not shared the deposit amount.
We'll record that you will pay the proportional bill amount to them.
No, in the trial court also, we have agreed, your lordship, they are not coming. They're expecting the
They're
huge,
not paying, my
expecting the
lord.
huge amount,
If
your
they have
lordship.
paid,
Sections in the order of law and a single judge, 5th April 2024, relates to restoration of the electric supply, which is an essential amenity, to the flat of the petitioners. Full stop. Paragraph 4 and 5 of the order reads as under. Report paragraph 4 and 5. Full stop. Thus, as per the paragraph 4, the petitioner is expected to perform his part of the obligation by sharing the bill amount proportionately and pay to the same to the respondent electricity company, which is a condition for him to be discharged for getting the restoration of the
There is
power
already-
supply. Also, learned advocate paragraph for the petitioner stated that if the proportionate bill is not paid, the same shall be paid within 2 days. Full stop. Upon such compliance, if not done so far, the respondent number 1 and 2, 1, 2, and 3 shall forthwith comply with the directions of learned single judge by restoring the power supply to the petitioner's flats. Full stop. Within a day thereafter. Full stop.
My lord, one submission, my lord. They also have to comply with, in the paragraph 5, there is a obligation cast upon them to pay to share the transformer charges with respondent 5. I have issued several notices for recovery of it, and they
We
have
will
also
go
not done it.
beyond black and white in the order.
Yes, my lord.
We will not go beyond anything. The court says that proportionate bill and you supply. That we have said.
Yes, sir.
Any
In-
other charges, we are in contempt jurisdiction, not concerned. And you have to comply with first,
Yes, your lordship.
even before demanding any other charges. That is very certain. If the compliance is not done, then what will do? Supplying the power. Even after the payment of the
Your lordship,
proportionate bill to the by the petitioner, the respondent shall be exposed to the aggravated form of contempt.
your lordship, they have not, because from the 2019, I've been deprived of my electricity. I am ready to pay, but now the proportionate amount of with respect to, I'm not clear, because for the installation of the electricity, or I'm ready to pay the whatever the charges are there.
Whatever it is paid, you proportionally pay.
That may be kindly
I'm not
recorded, my
in-
lord, in the order. Their statement, whatever they are saying, that may be kindly recorded.
I am not in the
Otherwise, they
position, your
won't pay.
lordship, now. I'm not in the position, I've been deprived.
Not in a position to pay.
No. I'm not in the position there because I'm out of the flat, because there is no power supply.
Then work out for yourself. We'll say within 1 week, thereafter within 1 day.
Maybe.
My lord, one more submission. This is a HT connection. We are going to give the,
According to what amount is supposed to.
no, we are not supposed, if it's the settlement between both of them, I have given up to the HT line, HT point, and they will have to share among us themselves by making the compromise with them.
We are ready
Don't
to
have
pay, your
anything to do
lordship,
with
but
that.
they are not ready agreeing for the
The
amount.
last bill given.
Sir, my lord, in whose name the bill is there, they are continuously paying.
There are no.
And these two people have not paid this one.
You are out of flat since how many months?
From around 2019, I've been,
19.
yes, your
Not
lordship.
paying any.
No, lordship,
Not
they have
paid.
removed the electricity. I was not in that position. How can I stay? Because they have filed the FIR on me. Now I'm in the tenanted house, your lordship. I purchased my flat. I'm paying the EMIs and all, but I'm not able to enjoy the property, your lordship.
We would not like to work out any formula in the contempt. You just pay and they can dispute, then come back. Pay the last bill or whatever, 50% of the last 3 bills average, whatever you.
Your lordship.
My lord,
If they give the notice, we are ready to pay, lordship.
my lord, our name can be
I have
taken
already
out
issued
because
an
we are not no way
So
connected.
shall we record that respondent shall intimate about the amount of the last bill?
Lordship, they know that we are not in the residence and they have sent purposefully.
How will you determine the proportionate amount?
They should tell us. We are ready to
Then
pay.
you will pay it.
Yes, your lordship.
Then you will not dispute it.
No. We are ready to pay.
Stated by learned advocate Mr. Swansub petitioner fairly stated that once the respondent or the respondent company intimates about the proportionate bill amount, The same shall be paid within 1 week.
Yes, your lordship.
Full stop. It was stated by learned respondent that the intimation about the proportional payment shall be given within 3 days from today.
Yes.
3 days, then 1 week, and then immediately 4th week. We'll
Much
dispose of the contempt.
Much obliged.
Contempt proceeding disposed of on the aforesaid.
This is number 5. So, RP Somsekre.
The order passing for exam, correspondence has been made. As per annexure F Miller, hereafter Miller, no progress has been taken place. Annexure F Miller. Pursuant to the-
What is where are the directions?
The directions are in page number,
Page 32?
page 32.
Then there is no direction.
Please, sir.
Nothing. Read it.
Accordingly, enabling petitioner file the representative with the additional document to reconcile now as the petitioner will be liberty to file the within a period of 4 weeks from the date of settlement couple of weeks. Thereafter, we have filed representation and the.
Notice. Notice written. 9th June.
This is number 6. To us money.
Then my lord. Not the husband, the complaint before the court. My lord, he has initiated proceeding against the wife, my lord, before the family court, my lord, seeking the interim custody of the children, my lord. He has filed the main petition for seeking the custody of the children. In the meantime, number 2 was filed, my lord, seeking the interim custody. Considering that the family court has passed an order, my lord, as per annexure A, at page number 21, my lord, granting visiting rights, my lord, to the complainant on 2nd and 4th Saturday, my lord, between 10 AM to 6 PM, my lord. The respondent has not complied, my lord. They said orders 3 times. I approached the police also, my lord, by filing complaint before the Yeshwanthpur.
Where is the order? Custody of child, your father.
Yes, my lord. I'm the
Your
father,
father.
my lord. File the petition.
Page 26.
Page 21, my lord.
Page 26.
21. The operative portion is at 25 and 26, my lord.
Syed Muhammad, aged 6 years, and Syed Yusuf, both are male child.
No, my lord. One is first child is 7 years, my lord. Second child is 4 years, my lord.
Both are male child.
Minor, my lord. With the mother, my lord.
Both are boys. Sons.
Yes, my lord. Both sons, my lord. On 2nd Saturday and 4th Saturday.
Notice returnable on 15th of April.
This is number 7. Prabhu Godathurgi.
Specific direction.
Notice returnable on 10th of June.
But not stop, because not since a service matter, or there is specific direction to appoint him for the post of fireman, not within 2 weeks. Not taking into consideration of the coordinate judgment of this honorable court. Not lordship, not directed them to not within 2 weeks, not the considered is not the court to the post of fireman. Since they have not considered not the.
Therefore, notice where is.
But start date not.
Short date is not.
2 days not. 2020 is the not the appointment.
Then you cancel the vacation. Going to cancel the. Yes, next.
This is number 8. The Arnav Bagalwadi.
Notice returnable on 11th June.
This is number 9. Mr. Prithvi Odia.
Page 14.
Notice returnable on 12th June.
This is number 10. Orders.
Last, the way the swamp has been encroached. And they have filed 3 compliance reports wherein they have the photographs, your lordship could
Contempt petition does not survive and stands disposed of. However, it is clarified that if the complainant has still any grievance, he is at liberty to approach the appropriate forum in the manner known to law.
Number 11. It's a PL matter, Mr. Venkatesh Somareddy.
Petitioners counsel.
Now reply is filed, man.
The first time it's coming.
It's coming the first time.
First time, my lord. It's the Mangalore.
Connected matters. My lord, in WP 6183 of 24, my lord, there I have filed my statement. In this, they are just seeking for a consideration of the representation, my lord, the first prayer.
My lord, bar association before the honorable court because the difficulties the advocates and general public are facing. My lord,
Then the
registration.
bar association can solve the dispute.
No, it's the first time. In fact, this bar association is coming for the first time in
No need-
APL, my lords.
No need to involve the.
It's because, my lord, registration of documents in practically it's everything is broken down.
You just take instruction, then we'll dispose. It. Since they are the lawyers. Concerned, directly concerned.
Lord, I'm trying to justify the Kaveri 2, my lord, and anyway.
No, my lord.
This connected petition is there.
There, my
My
lord.
lord, may I submit the Kaveri
they have
2.0.
The resolution also.
When it is coming up?
My lord, that is posted to 24/3, 24th of March.
March.
Yes, next Monday.
Yeah, and that's may I submit one aspect, my lords. This Kaveri 2.0, my lords. Earlier Kaveri 1.0, there was no problem, my lords. Kaveri 2.0 is not aligned with the provisions of law. For example, my lords, undivided right, a person has right to sell undivided right. This doesn't provide for it.
Well, then
The
you
huge
make this-
difficulties, my lords, because
You make the suggestion and solve it.
but we may make one suggestion, my lords. The stakeholders must be there because I feel the software is not prepared in tune with the law. That's the problem. Therefore, it leads to breakdown and all the problems. Lawyers are not able to implement the provisions of law. They prepare the documents. As software doesn't accept it.
So you are
My
agreed
lord,
by
that
the,
is what they are suggesting.
please.
The
you are agreed by the
representation.
kind of software or the implementation?
No, my kind of software itself. There's inherent difficulties in the software itself, my lords. For a vacant space in an apartment, it doesn't provide for registration at all. Kindly see, we have set out, my lords. Your lord may kindly go to page number 50 for a moment, 50.
But I know nothing hard about the software.
No, this 2.0, my lords. That's conveyancing. Those advocates who deal with conveyancing, they're finding difficulties every day.
Coming up, we'll look into it,
Please.
if it is possible. For 24.
Please.
The connected petition is slated to be listed on 24th March. This public interest petition shall also be listed on the same.
In fact, state is also losing, my lord. There was crash of the software earlier, my lord. And the documents are not
They
registered,
will
my
look
lords.
into it. Let us
Please, it will help a long way for all the advocates, my lord,
will
to
impress upon them to find out somewhere.
do their job properly, my lord.
Yes.
Seek the assistance.
Yes.
Kind orders of this honorable court, my lord, so that law is implemented, not the software.
You suggest what is to be done.
Please. We have suggested, my lords, we will also be very happy if the Lord directs, my lords, that we will form the very senior advocates, my lord, who are expert in the field, my lord. We will give suggestions. We have formed it, but they should be part of the process. We are ready, my lords. As my lord.
We'll do it.
Please.
This is number
Great.
12. Shiv Prasad Santanagoda.
For R7.
This was heard, no?
Yes,
Yes, madam.
Just remind me.
please. But this was the encroachment, my lord, made by respondent number 9. Pursuant to orders of this honorable court dated 12/7/2023, there was a survey conducted by the concerned authorities. It is the state corporate, the district corporation, as well as the officers of the NHAI, to verify, my lord, whether there was actual encroachment so far as the petition, respondent number 9's buildings is concerned or not. The
So who
survey
has
conducted, my
Who
lord,
has
report-
encroached?
respondent number 9, my lord, private respondent.
9.
Please, my lord.
What he has encroached?
National Highway, road.
National.
Yes, in my petition, page number 30, they,
Yes.
yes,
That after seeing photo.
yes, ma'am. There's a specific finding by the corporation saying that there's encroachment of the building pursuant to the, in fact, my lord, on the earlier occasion when the arguments were.
No, there you are saying they have encroached, madam. Same matter?
Yes, ma'am.
Yes, my lord.
You are saying that they have encroached.
Even the
Yes, I'm saying
report
that they have
was-
encroached.
Report
There is no
was,
encroachment for the simple reason 1985, my lord, the building was constructed. 2021, my
What
lord,
was
I'll just
Supreme-
give you a lot, my lord, the list of dates. Note it.
Yes.
Silva. What is it say? 1985, my lord, the building was constructed, serial number 2. Serial number 3, National Highway itself, my lord, gave us no objection. We, my lord, constructed the first floor and the second floor in 1992. Building plan, my lord, and if your lords come to my lord, serial number 6. Commercial tax department, my lord, was occupying, my lord, the first, second, and the third floor for the last 15 years.
Yes, I recollect.
And my lord, after 32 years, and my lord, the corporation, my lord, we have filed their detailed objections. How, my lord, the survey was absolutely, my lord, bad. And they have not, my lord,
That survey was undertaken when?
my lord, the survey was undertaken, my lord, on
Survey by BBM.
by the corporation.
PWD email. Survey, my lord, was ordered to be directed, was to be conducted on 12/7/2023. By order, it was conducted, my lord, on 26/7/2023. The report is also placed before lordship.
We have filed detailed objections. We have filed, my lord, the plan sanctions, my lord, of 1985, when we constructed. 82, my lord, 92, my lord, first and second, third floor. Occupation by, my lord.
But they have not taken any
Nothing, my lord.
steps. What's your-
Nothing was.
My lord, page number 31 of my petition may kindly be seen. I'll just close my arguments after that. Page 31 of my petition. This was, my lord, signed by the joint director. My lord, is at page number 30. Violation of building license during construction of Trishul Lodge. For a moment, my lord, page 31 may kindly be seen, my lord, of my petition. Page 31 of my petition. There are specific queries put forth before the planning authority, to which, my lord, there are specific replies that have been granted by the joint director. Page 31.
See, the entire list pertains to disputed question of fact. Whether there has been
Yes.
Construction in violation of law or not. There is no legal issue to be interpreted by this court.
I'll just take
This,
lordship
this
to
is
page
2017, my lord. Please look at, my lord, what my learned friend is referring to is 2017.
Page 31. I'll just take your lordship to that one paragraph. Thereafter,
No, there is no legal issue to be interpreted by this court, right? The list does not raise any legal issue.
Yes.
It raises the disputed question of fact,
Whether there has been
whether there has been encroachment of NH or not. That's all.
corporation
That
also
has to
says
be-
there is an encroachment.
It
NHI
has to
says
be
there is an
relegated to the
encroachment.
district court, my lord.
They go a step ahead
And
say,
both of you have produced your side of documents, you contending there is, the other side contending there is not.
I have produced
There is
documents
one
issued by the corporation. The corporation has given plan
Lord, there
sanction
is-
for ground floor only.
One floor, my lord, which is not
Four floors.
constructed as per the sanction plan. No setback area, my lord, plus they've encroached the road is the finding given. So they were supposed to leave 25 feet from the
You
building,
have
my
for
lord.
whom?
My lord, a corporation, my lord.
What action you have initiated?
My lord, there are 3-4 petitions from 2017. They've been filing
Mr.
petitions, my lord.
1985 was a
You
construction.
stick to your report.
Yes, my lord. We
Then you are
filed
not-
our statement of objections also, my lord.
You're not taking any action.
My lord, we will take action, my lord. The reason why we could not take, my lord, they had filed 3 other writ petitions, my lord, before this honorable court, before the single bench also, my lord.
Please
My
look at
lord,
the
I
sanction.
have
The reason why, my lord, we had to
Use.
come to the court. Because of the inaction of the authorities, we had to come to the court.
1985 building constructed. The commercial tax office, my lord, is in this building for the last 15 years.
My lord, right now it's there's
And
a
now
lodge and
2017, they say, my lord, the building construction.
So we'll say that any
Lord, I have filed a memo on 31st July 2023. My lord, along with the sketch. My
So
lord,
we'll-
which shows the encroachment.
Yes.
My lord, memo dated 31/7/2023. My lord, it is this report of the ADLR, Assistant Director of Land Records. Pursuant to the directions of this honorable court.
That's what, my lord, we have filed our objections, detailed objections, how, my lord, it is absolutely, my lord, lopsided.
So we'll say that any of the divergent reports by the different authorities
No diversion.
Which
Authorities have been together.
we are going to say yes or no. We are pronouncing an order.
Please.
We are not hearing now arguments. We are going to say in the conclusion, write down any of the, for the, if you want the operative portion, we'll read written here on.
No, I'm just clarifying. I'm sorry, Murad, if I.
So when we are
Second, I'm
dictating the
interfering.
order,
I'm-
pronouncing the order, no interference code. That is the first discipline of my court. Order you are not supposed. Order is prerogative of the court, right or wrong.
Yes.
So we are saying that in the divergent reports of the different authorities, and in that view, the disputed question of fact arising, the court is not inclined to entertain public interest jurisdiction. So not entertain. In today's date, you will get the after 3 days. Yes, next. View the appearances. Yes, next.
Number 13, Mr. Nitin Ramesh.
I seek
Yes.
a week's time to file my rejoinder, my lords. Saturday, I will.
It is PI again.
My lords, relating to the
Relates to the
child
sa-
safety helmets,
That
my lords, and the
Not
safety
available.
harness. I'll file my rejoinder.
Rejoinder.
Yes, my
When shall we keep?
lords. 2 weeks' time, my lords, any day.
Tell the date. 16th of April.
Please.
16th April, as
Great.
requested. Yes.
It's green bench matters, cell number 14, Mr. Rudra Papi.
For the petition, my lord.
For the respondent number 6.
Now there is an order of conversion.
Conversion and also, my lord, as well as
My
the
lord, that is not to be
against-
challenged.
stone quarrying, my lord, business
Is there is
carrying
no
out by the, my lord, respondent number 6, my lord.
With common pleader, there is no remedy against the order of conversion.
My lord, it's coming up for the, my lord, there is, I'd just like to cross verify and make my submission.
Just verify and we'll make.
My lord, apart from that, my lord, there are 2 proceedings that are pending in OS 217 of 2023 and WP 18911 of 2023. Pertaining to the same thing, and that has been stated, my lord, in,
Disconnected, connected.
not connected in respect of the same extent of land. My lord will get it page 27. My lord, the third prayer.
This suit is also pending.
Please, my lord, writ petition, another writ petition also pending, my lord. During the pendency of the writ, my lord, they have started, my lord, in view of the order passed by the, my lord, respondent
I-
number 3, my lord.
Why separate petition?
Stone quarrying business, they are started, my lord.
File IA in that petition.
My lord, because of the reason that, my lord, the green bench matter, my lord, it is listed before the Supreme Court.
Yes.
Earlier, it was listed before the single bench.
This petition relates to what? 18911.
My lord, the interim order passed by the single bench, my lord,
It is not a green bench matter, 18911.
my lord, not my lord.
So what is that matter?
KLR matter, my lord. To decide the title of the petitioner, my lord, this land has been granted, my lord, to the ancestrals of the petitioners, my lord. For that reason, my lord, we have filed the writ petition before the learned single bench, my lord. Learned single bench passed the order, my lord,
It is your petition.
in annexure W, my lord.
The other petition is filed by you.
Please, my lord. Annexure W, my lord, page number 192 to 194, my lord. Interim order also granted, my lord, in that matter, my lord. Subsequent to that, my lord, the
Conversion of land from agriculture to industrial.
Yes, my lord.
Is that order appealable?
My lord, 49, my lord, could I just make, clarify and make my submission? 1 week, my lord.
1 week.
Madam, for respondent number 6 in this case.
25th.
Copy has not been served, my lord.
Copy will be given. 25th at 2:30
Yes, my lord.
for this purpose.
notice not ordered, my lord.
Submissions, my lord.
Till then, your lordship may kindly some interim protection not to the petitioner, my lord. Stone quarrying business.
On
is running, my lord.
25th. If there is a remedy, then we'll relegate you to that. Because of the pendency of the suit and other petition, even otherwise, yes.
Cell
Next.
number 15, SY Shivali.
This matter not revision authority order is challenged.
This order is passed by.
Passed by the
Means you
revisional
again
authority
this.
dated 24th April 2024. Not rejecting
Revision
it.
will be available under rule 54 or 53, 53.
53, my lord.
53.
I had doubled the remedy of revision. Now the revisional
Well,
authority has
definitely.
rejected.
Where is that order of revision?
That is at page number 15, Lord. Revisional authority has rejected my revision petition on the sole ground of limitation.
On the ground of limitation.
Please.
My lord, according to the petitioner, the order was not communicated. And so the review petition couldn't be filed in time. My lord, the other contention is, my lord, the extent is usually 2 acres, my lord, for stone quarrying as per rule 15A1. But here he's seeking for quarrying in respect of 1 acre.
Recently, my lord, rule is amended. But now even 1 acre is applied. That if the land is falling within the cluster area, that can be, lease can be executed. The rule has been brought recently, not in the month of December 2024. Not in the instant case, not only on the ground of limitation, my application is rejected. The endorsement is nothing to do for the reason that
Where is the memorandum of revision application? The next, anything is said about the delay?
please note. Page number 37, annexure C.
37.
Translated at page number 38. Sorry. 41.
41.
41. Translated.
41.
Please.
40. What you have said about the delay? Any averment? Any explanation? 41 is the revision. So this you file in this format.
It was a format, no? By filling the format they have filed.
So there is blank. Is the application within 30 days of the expiry of 60 days?
22, 25.
Column number 6, page 42. Blank. No reason is given. Absolutely silent about the delay. It is condonable.
No, man.
No,
not
60 plus
6 years.
60 plus 30.
90 days, it's all right, but this is 6 years, 8 months.
No. That's right. It's long delay, but it is 90
90
days
days.
plus 30 days. Is it so?
30 days.
90 days from the date of impugned order, or 30 days after this period of 90 days, giving valid reason. So up to 30, next 30 days is condemned.
60 plus 30,
Yes,
that is a
we'll
provision.
give the provision.
Not even otherwise, not this endorsement is not sustainable. In view of not a recent amendment made to not KMC rule 8B. Under rule 8B, not the applications filed prior to 12/8/2016 not becomes eligible for consideration. The question of law is involved. Other 4 writ petitions are pending, not it will be considered along with not. I will give the numbers.
It will not nullify the divisional order. Those who are gone are gone. Within 90 days from the date of communication, provided satisfied 30 days, 30 days grace period. Otherwise, a special provision for total period available is 120 days. So is it not your case that you are not communicating? You have not said nothing.
Was not the petition has pleaded in the writ petition that the communication was not intimated. Endorsement was not supplied to him.
Where is that?
Not that.
In your revision application also you not stated.
Yes.
Week not, I need it. Next week not, I will get this.
Why?
I'm sorry, not because the other 4 writ petitions are similar writ petitions are pending. The question of law is involved here. The thing is, not in my endorsement application was filed in the year 2013 not, for seeking grant of lease not. That application came to be rejected in the year 2017 by invoking rule 8B of 2016. Not that rule 8B of the year 2016, not diluted in the year 2023. That is by way of amendment.
Which rule?
This law is present to.
Which rule?
The rule 8B of KMC.
8B.
1.
Of which amendment?
Came
23. 23 amendment.
17/3/2023.
23 amendment.
Please. Kindly peruse this amendment.
Then if you are relying on this rule, this is beyond the purview of the controversy. You can go there and make a representation. Relying on rule 8B.
I'm relying upon this rule 8B1. This rule 8B1.
Not even otherwise, the area applied for is less than what is required.
For that, there is a recent amendment in the 2024 December. We have it next week. I will not produce that amendment.
Heard learned advocate Mr. Shiva Yogi for the petitioner and learned additional government advocate Srimati Nilofar Akbar for the respondent state and its authorities upon service of copy of the petition in advance.
Present claim is falling within the rule 8B1 present.
The challenge in this petition is directed against order dated 26/4/24 passed by respondent 4 dash the revision authority in the revision petition number 30 of 2023-24, dismissing the revision application and in turn confirming order of endorsement dated 17/2/17 issued by respondent 3 passed by respondent 3. The senior geologist, paragraph. By the said order, paragraph, dated 17/2/17, the application of the petitioner for grant of co-release for extracting ordinary building stone in part of land survey number 73 at measuring 1 acre, which is stated to be government land at Kajjari village, Arane Benur, RANE, BEWNUR, Taluka, Haveri district. Full stop. The application was made in the year 2013. Paragraph. While rejecting the application of the petitioner, comma. Competent authority noted that in view of the amendment to the Karnataka Minor Mineral Concession Rules 1994, or more particularly Rule 8 into 5 of the said rules, comma, the land that the lease for minor mineral building stone will have to be granted by conducting tender cum auction process. It was therefore recorded that the application of petitioner became ineligible in view of Rule 8 capital B into bracket 1 of the rules. Therefore, was liable to be rejected. Full stop. Revision application against the aforesaid order dated paragraph 17 to 17 was filed by the petitioner, which was delayed by 6 years and 3 months. Full stop. The revision was competent under Rule 53 of the very third rule. 53 of the Karnataka Minor Mineral Concession Rules 1994. The said rule reads as under, then quote Rule 53, 1, 2, small Roman 1, small array, sub rule 1, regular, sub rule 2, regular, then proviso, then 2A, then 2B, 3, 4, 5, all should be not needed to be quoted, but dot, dot, dot. 2B, dot, 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 2, 3, dot, 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 4, dot, 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 proviso, dot, 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 yes. Full stop. Thus, the rule making authority has provided period of 90 days from the date of communication of the order to be subjected to revisional proceedings. Full stop. As per the proviso, if the applicant is able to show the sufficient cause for not making application within the said 90 days, comma, further grace period of 30 days is available from the date of expiry of the said period. Full stop. While dismissing the revision application on the ground that it was beyond the limitation, comma, the revision authority observed that the revision petition was highly belated and was not therefore maintainable. Full stop. Paragraph. In addition to the said aspect, comma, it was noted by the revision authority that as per Rule 15A, capital into its regular 1 of the rules, no co-release or license will be granted with the extent less than minimum as provided in Schedule 2A Roman capital 2A of the mineral concern, and that such extent in respect of the instant mineral is 2 acres, where the application 2 acres, comma, implying thereby that if the application is made for a land comprising 2 acres, comma, it is not liable to be considered. Paragraph. In addition to the above aspect, comma, the further aspect considered by the reviewing authority is that the proposed stone pouring area is coming within 10 kilometers, 10 kilometers of the eco-sensitive zone of the Renebennur, Krishna, Muruga. Full stop. While the observations are made by regional authority, paragraph. On the aforesaid aspects also, common. What is weighed with the regional authority is the delay of 6 years and 3 months, which rendered the division petition incompetent in law. Full stop. While learned advocate for the petitioner argued in vain that he was not aware about the learned advocate petitioner argued in vain, not while, that he was not aware, that the applicant was not aware about the passing of the order dated 17/2/17 and that he was not communicated the said order. Full stop. While this ground is coming forth for the first, this ground is coming forth for the first time in the course of the hearing of the petition, and the memorandum of revision application is seen, which is part of the record of the petition. Not a whisper is made about the delay aspect. It was never the case of the petitioner that he was not communicated with the order. In any view, full stop. The court is not inclined to entertain the petition for the reasons recorded above. Full stop. The petition is dismissed as meritless. Full stop. At this stage, learned advocate for the petitioner submitted that Rule 8B as amended in the year 2023 would come to rescue of the petitioner. Full stop. This aspect is outside and beyond the scope of the controversy in this petition. Full stop. Notwithstanding the rejection of this petition, it will be open for the petition to approach the competent authority seeking benefit of Rule 8B if available in law and in facts of the case. Also, the competent authority shall consider such request if made entirely on merits and in accordance with.
Obliged.
Much. Yes. Number 16, Mr. Srinivas K.
So what happens?
Speaking Millard, only writ of mandamus.
Correct. We have
Next
seen.
day.
What happens
65.
when the leaseholder dies before execution of lease deed?
My lord, there is Rule 19C, my lord.
Rule 19.
19C. It's
Earlier
legal.
also some petition had come.
Yes.
Rule 93.
19C of the Karnataka Mine and Mineral Concession Rules, my lord. 1994.
Which rule?
19C,
19C.
capital C.
19C. So then you are supposed to execute the lease.
My lord, it's come up for the first time. My lord may grant me a week's time and I'll.
Shall we issue notice?
No, they are already
My
considered.
lord,
my
just a
lord.
week's time, I'll intimate the concerned officer and then.
Kindly turn to annexure P, my lord, at page 68. 68. They are already considered.
While pressing for relief of execution of lease deed.
Notification was issued
Of
in
the petitioners from a learned advocate and so and so relies on Rule 19 capital C of the Karnataka Minor Mineral Concession Rules 1994 to submit that the petitioners as the heirs and legal representatives would be entitled to step into shoe of the grantee public lessee and would be within the right to get the lease deed executed from the competent authority in respect of the co-release granted to other deceased father, deceased grantee. Full stop. Notice returnable on 26th March will do, 26 March. Learned edition government advocate accepts notice and shall take instructions to the returnable date, paragraph, looking to the narrow compass of the controversy, comma, the petition shall be listed at 2:30.
Obliged.
Number 17, Mr. Vamshi Krishna.
For the petition. Well, it's a writ of certiorari and mandamus, my lords, pertaining to a lease application for stone quarrying in survey number 241 pertaining to a particular village, which was rejected in 2013, my lords, on the ground that this particular survey number was handed over to Nandi Infrastructure Corridor, Nice Road. However, my lord, subsequent on further verification, we come to know that such handover to NICE has never happened. And thereafter, my lords, in the year 2023 and 2024, the petitioner also comes to know that in the same survey number, 3 other individuals have been granted this quarrying license. So now I'm here before this honorable court after such revelation, my lord.
This requires notice. Notice returnable on.
Highly obliged, my lords.
It will go to 2nd April.
Obliged, my lords.
So 18 is adjourned. Still number 19. It's a writ appeal to Prashant PN.
Delay of 74 days. Who appears? Delay is there, notice returnable on.
Lords, is a party in person, my lordship directed my lords to appear for him. The notice sent by this person, my lords, against, is not received the notice, my lords. Is a party in person.
Then send it by registered post.
Please, my lords, the issue is that, my lords, the suit is pending, my
Notice
lords,
was
posted for arguments, my lords. It's a simple matter, my lords, where khata was sought, joint khata.
Formalities will have to be completed. What
My
can?
lords, notice was taken, my lords, against the party in person, my lords.
Where is that? There is no notice.
My lords, the lordship has directed us to take the notice, my lords. On 21/2025, notice was taken, my lords. I filed a memo also, my lords, on 21/25.
To serve the party in person.
Not accepting, my lords. Not accepting, my lords.
It was stated that the notice was issued. However, the respondent party in person has not accepted the same paragraph. The formality of service, nonetheless, will have to be completed. In that view, the petitioner is permitted to serve notice of this court through registered at post. So for that purpose, the registry shall issue press notice to be making it returnable on 9th of April.
A suit is set for final arguments, my lords. Suit is set for final arguments, my lords.
When it is kept?
My lords, 19th, my lords, next is on day after tomorrow, my lords. The arguments of the defense is going on, my
At
lords.
least expect the High Court to be faster than the cute court.
Grateful, my lords.
Yeah. We'll deal it little earlier.
Please, my lords.
28th of March. Serve them.
Grateful, my lords.
Still number 20. Mr. Divya Purandar.
I appear for the. This, my lord, is that matter relating to the bank guarantee. But we've not yet got any instructions in so far as payment is concerned, because my lord, the problem is it has to go to the board, being a high value amount. So unfortunately, I'm not in a position to, I'm sorry, my lord, I have not been able to get instructions on that as to whether we can make payment, because that is what his lordship had indicated.
Yes.
Unfortunately, this matter has to go to the board of the bank, and if I've not been able to get instructions on whether it's possible, and without an order of the court, also it's very difficult for the people in Bangalore office to send it, not lordship's minor and friend knows how banks work.
What was the query?
But the issue, my lord, was with respect to payment of certain monies under a bank guarantee. The bank had not made payment of the money. Therefore, my lord, they went to the banking ombudsman, filing a complaint saying that the bank has not made payment of the money. They claimed that it is invoked. According to us, it is not invoked. But anyway, my lord, that is the complaint. Banking ombudsman said, I don't have jurisdiction over this issue, and closed it. That was challenged before this honorable court. This honorable court not held that the banking ombudsman has jurisdiction. but then went on to decide the matter on merits and said there is an invocation and that you ought to have made payment. You did not make payment, your conduct was dishonest, and thereafter imposed costs on us and interest at 18% on the entire amount of money, my lord. And I think, my lord, on the facts as they exist, I'll be able to demonstrate, my lord, that there was no invocation as understood in law. First. Secondly, that the invocation is not in accordance with the bank guarantee. And third, my lord, it came after the period of the bank guarantee had expired.
What came after?
The letter for invocation was received after the period fixed under the bank guarantee for invocation. And therefore, my lord, the finding made by the court that there is invocation itself, in my humble submission, may not be correct.
We have sent it by email, received by them on email.
I'll show
my lord the time period. And therefore, my lord, their argument was email is not
there are
sufficient.
two arguments, my lord. I'll show your lordship.
IT Act, my lord, specifically provides for it, and there are judgments which we have. Anyway.
Anyway, my lord, whether the invocation can be done in that particular fashion or not is something your lordship will have to examine and consider.
So you want to argue, then argue. You want
Ready.
to-
I'm ready to make submissions if you.
Time, then take time, whatever, either.
I don't know if I'll get instructions, not as instructed by your lordships. That's the only thing. Otherwise, I'll have to argue the matter on merits. I'll have to.
So we leave it on you. They're not able to decide.
No, your lordship may then fix a date, my lord. We'll argue on that day, any date that your lordship fixes. It's a short point, my lord. I'll take what, half an hour.
Only thing that at least I am suffering from vice of forgetfulness.
Beg your pardon?
I am suffering from vice of forgetfulness.
No.
I'll give
So every
list of-
time it
list of-
adjourns.
list of dates is here. My judgments are here, my lord. Notification.
No, we are,
I'll assist
our
you.
judgments also here, my lord. List of dates, everything is there. We all read.
Every time you have to recollect.
I know, I understand, but it's a, my lord, we'll have, my lord,
And at the same time, granting time also necessary because we are not clear what to do. So therefore also we grant time. So your second, anyway, argue on 26th.
26th.
26th. We'll
Yes, we'll argue.
give for it. 26th of
27.
March.
my lord. Need be on 27 because the instructing council is in Delhi that day. So
27.
one day, my lord. 27, great.
Still number 21, the Devraj case.
Lordship connected the writ appeal 263 of 2025 posted on 24th of this month, my lord. It may
Delay. Delay up to 28 days.
please, my lord.
Notice returnable on
24th is the date is fixed, connected the writ appeal, my lord, arising out of the same judgment.
When it is fixed.
24th, my lord, 24th of please.
24th.
Please, permit to serve the copies on the council.
It will be open for the council for the petition to serve copy of the delay and donation application as well as writ appeal to the council appearing in the other connected.
Please.
22.
Same, connected matter.
Same order.
Still number 23, the Sundar Raman MV.
Spot number 3.
This is
That
a
is that direction of the Supreme Court.
direction of the Supreme Court.
But then what to do? Because somebody has expired, some of the respondent.
They had expired earlier itself, and I told my lord the amendment was not carried out in the writ petition.
That has to be, at least formality will be.
I don't know if who's appeared for them.
Parties are also not served.
That is what.
Service is not complete as far as all the parties are.
Served.
No, the
Service
problem.
Illa.
No, the office objection is not been complete despite the court's order that the case shall be taken up for fine hearing on 5th March. They are not, even today, as on today, there are so many objections, complaints are not done.
But then.
And the Supreme Court has requested women as, with that matter may be taken up for vacating of interim order.
We are quite aware, but then the formalities of service and what can be done.
Because
it has to be.
The Supreme Court. I'm not saying. Service complete. There is Service is complete.
Once we give time,
My lord,
then we'll proceed.
of course, my lord, in the Supreme Court, my lord, a statement was made that they were not given a proper opportunity and papers were not served on them and therefore they could not argue. But that was not the case. Your lordship heard both of us on that day. Lordship, may kindly see the order of
And
Supreme Court.
Supreme Court has wanted the High Court to proceed with that.
Proceed, my lord.
But then without
That's what
service,
statement which was
without
made.
service, how can we do?
No, no, I'm not saying that. I'm saying, my lord, everyone that seems to have been served, not except the respond number 12's LRs.
One of the that part we can conclude today. That the heirs can be granted.
Yes.
I don't know who are, but I'm not appearing.
So where is that heir application for bringing heirs?
They're not, you should notice. You should
The 2,600 days of delay. Where is the application for heir?
The application, my lord, is filed IA number 1 of 25,
Heir number?
2 of 25.
2 of 20.
LR application has been filed already.
You've served these individuals. When
Steps 2 of 2. Because we weren't able to find that.
Why they are not being served?
they have been served, notice what I'm told.
They are served, all are served, then we'll proceed.
No, all of them are not been served.
That is the only now, this is the only formality to complete it.
That's the only formality.
R12 to be brought on record through the heirs of the R12.
Heirs of R12, my lord. That is,
Lots of public knowledge. I appear for R12 to A to D, my lords. I undertake to file wakalat on that.
that's solved.
Heirs you are appearing.
Please, my lord.
Then file it, we want to proceed with this matter.
Please,
because
please,
of the Supreme Court's
I shall
opinion.
file it.
We can't while away the time in this.
Please,
But for this procedural,
please.
please.
I shall file it today.
So we
We'll
can
file it
grant
today.
the application.
Yes, yes.
We'll delay, condone the delay, because as far as the bringing heirs in the pending proceeding is concerned, the standards are very liberal as far as delay is concerned.
Some delay is there, 80 day petition.
Sizable delay, we are aware.
About 2,000 days delay.
1,600. Where is the tie?
As a matter of fact, my lord, in the writ petition, they did not bring them on record. In the writ petition that they filed, they did not bring them on record. My lord, lordship may kindly see the cause title, my lord, in the writ petition itself. At page 61 in the order.
No, not I. Heirs. Heirs, bringing heirs. And 11 bringing heirs.
Ramanna's.
ಹೌದು, ಮೊದಲು.
First said it is not there. Very good. No problem.
ಎಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಎಲ್ಲ ಸಂತರಿಸಿಲ್ವಾ?
How did they find out it was possible?
Legal representative was R12. It was not brought on record.
ಇಲ್ಲ,
I'm sorry. ಕೂಡ writ petition.
ಗೊತ್ತಿಲ್ಲ ಅವ್ರು ಹೋದ್ರ ಯಾವಾಗ this what actually has happened is in the writ petition against which the writ appeal has been filed, they were never brought on record before the learned single judge itself. By my lord, my learned friend, Mr. Kemparaju ought to have made them parties because they have passed away long back. They are, my lord, the heirs of one Ramanna, who is the son of Muni Bhairappa. In the writ petition, they were not brought on record. Though, my lord, they had passed away long back.
No, in the impugned writ petition, no order would affect the 12th respondent who was not brought on, whose LRs was not on record. So for the other two writ petitions were there, it is on those cases that person is an affected or interested party. As far as the writ petition impugned in that, the Ramanna was not a necessary party because he was not affected. But
Therefore, my lord, if the writ petition order doesn't affect them, then we can proceed without them.
now, since an application has been filed to bring the LRs,
Lord, no, not reflected in the cost settlement. We've said that. Lord, at page 7, para 3 of the application, last line. Para 3, my lord, it is submitted the judgment dated 27/9/24 and so on, so does not reflect the legal representatives of late Mr. Ramanna. Doesn't have it.
so that the formalities should be complete. Your Lordship may bring them on record. I don't think my learned friend has any objection to that.
I only filed the application. Yes, yes, of course. Yes. No delay application. Yes.
Your Lordship have it next week itself, next Monday.
Yes, I'm ready. There is no delay application.
Serial number 2 and 3 and I have complained, I have perused the entire copy regarding statement of objections as well as the IFRS. Okay, 2 and 3 to be overruled. Office objections were 2 and.
Not in this.
Please, my lord. Roy Taras D, my lords. Please. I shall file it today itself.
Yes.
Twenty-seven.
27.
27 and 26.
26 would be.
No, that's.
Yes. 26 or 20, either date, either date. 26.
Would be all right?
Yes.
Okay, very well, madam.
Same here. Yes. Bye. According to us, there's no delay, my lord, because they were not parties in the court, which is why we did not make an application for condoning delay.
Prasanna Kumar. I am person who is entered.
IAPR.
Number the commercial appeals, still number 24. So
I appeal for appellant, my lord. This
commercial appeal, the suit for recovery of money based on a memorandum of understanding regarding some work done. And the amount was invested, part of the amount was paid by the defendant, and the remaining was to be paid in 20% per year for 5 years duration. But in between the 2 years was not paid, so the suit was filed for recovery. And the entire transaction took place in Gadag, and the suit was filed in Bangalore. And no jurisdiction at all, either, and defendant is residing in Gadag, not here, not Bangalore. In both ways, jurisdiction was not there. I filed the return statement, then I have sought for a stay also, my lord.
Then you have to deposit the amount, money decree.
Money decree, some portion could it be, my lord? I am, because it's an education institution. Institution is not made a party. The principal is made a party. Institution is also not made a party. Against the wrong person. That is, of course, that's a technical aspect. But the difficulty is they are not having that much of money as of now, my lord. That's why I beg your lordship to.
Mr. Senior Counsel, don't press for this stay. We'll just issue notice. And run the risk whenever the execution file, you come before the court.
Could it be 50%, my lord? 50%? Subject to the, I will try to get a loan and deposit.
Lord Learned Senior so and so for the appellant. The present appeal is directed against judgment and decree dated so and so passed by Learned 88 additional civil and session judge Bengaluru in commercial original suit number 154 of 24, whereby the suit of the plaintiff came to be decreed and the defendants are held to pay sum of rupees 6,16,000 and 38,40,000 jointly and severally with interest at 18%. Full stop. In the facts of the case, there shall be notice to the respondents returnable on 10th of June. Full stop.
The records may be called for in the meantime, my lord.
Learned advocate for the learned senior advocate for the appellant prays for stay, since it is a money decree, no stay can be granted except putting the appellant defendant to the terms of deposit of money in that view, on condition that the appellant deposits 70% of the
70%.
total.
Or bank guarantee, my lord. If I can get some loan from the bank, I can get the bank guarantee, my lord. Either way.
Then do it 50% and 50% bank guarantee.
Otherwise 70%, my lord.
Then you deposit bank guarantee for entire amount will not while granting stay.
But the amount has not become due. 5 years was that period. Anyway, that's on merits. I request your lordship to show some. If it be 50%, I think I pray for your lordship to grant it.
On deposit of the amount of 50%, and further on condition that the balance that the out of the balance 25 out of the balance 50%, 25 bank guarantee shall be offered for the half of the amount. So 50% you deposit and further 25% bank guarantee. The amount of 50% shall be the deposit of amount of 50% of the decreed amount together with cost and interest shall be before the trial court and which shall be made before the returnable date. The bank guarantee shall also be given to the trial court.
About 8 weeks, my lord.
It more than 8 weeks, Mr.
Date, my lord? June.
10th of June.
Very well. Apply, highly obliged.
Once the amount is deposited with the trial court shall invest the same with Nationalized Bank in a fixed deposit, cumulative fixed deposit, initially for a period of 1 year and renewable subject to the further orders which may be passed by the court.
Records also may be called for, my lord, because one of the grounds is opportunity is not given to me. That's why.
Record and proceedings shall be called for so as to read this court from the court concerned before the returnable date.
Apply.
Bank guarantee you give within 2 days.
No, may not be, my lord. I have to
Sorry,
approve the bank
2 weeks,
for the remaining 50%,
25%.
25%.
Yes.
I'll
So
try, my lord, that
So
deposit, of course, time has been
deposit on or before the returnable date, and the bank guarantee for 25%, beyond 50% will be within 2 weeks.
2
Correct?
weeks. Very well. Okay.
Still number 25, Mr. Janardhan.
So the caveat, it is the, under the arbitration, section 37, I have, when it's the arbitral award, I have filed an
Notice
appeal
returnable.
before the,
Notice written on 12th June. $34 is rejected.
yes, 34 rejected, against which I prefer.
So number 26, to Vikram Muni Rajgopal.
Date may be given that, the execution, that is posted in 29.
What?
That earlier matter. This matter, but the execution has been filed, 29.
Take time there.
But
It
that,
will be open for the petitioner to pray for time in the execution process. In view of dependency of the appeal before this court.
yes,
May I submit, my lord? In that execution, it is only appointment of chartered accountant. Money is not figured out. Chartered accountant has to be appointed, even that they are opposite.
That is all.
That is all, my
no,
lord.
not that matter. It is,
Execution
kindly
is
say,
not clear. Can you see the order?
kindly say, what happened? It is not only appointment, but it is regarding the arbitral award is like that, madam. Kindly say, arbitral award
Nice.
is passed, madam. Kindly page 120, madam. 123, madam.
What is the award? Let us see.
Section second para 3 of the award, 123,
133.
123, 123.
123, yes. 120.
The tribunal directs the parties to get the, first one, it is the firm stands dissolution is held bad. But third one is directed to so counterclaim, rupees counterclaim, 8 rupees 3 crores settled, except that 2 and 8. Other things to be resolved through a appointment of the arbitrator and the proceed with the matter. No, my lord, the question is that requires to be, my lord, if the matter, my lord, if this court comes to the conclusion, my lord, it is valid, my lord, then the whole process would be of no use, my lord. That is why, my lord, it requires, my lord, otherwise the whole accounts, everything will requires to be go on auditing and everything. It's a voluminous account and everything to be done, my lord. That is
Page
why
123, para 3, my lord. Para 3, my lord, of the award.
yes, that is what
The
I'm-
tribunal directs the parties to get the account scrutinized, verified by a chartered accountant and get the claims and counterclaims except so and so be settled. I only filed to that. effect.
Verification of the accounts is good for you
That
also.
is,
Good for everybody.
What the question is, main question is according to us, the firm is dissolved. But if that were to be upheld, then the whole process of other process may not arise. That is the reason.
This implementation of this clause will not prejudice anybody.
It is.
it's not be prejudicing,
It will be,
because,
my
my lord,
It will be.
the partnership.
Will say any action which may be, any measure which may be taken, any steps which may be taken
29th.
pursuant to the award in the execution, if, write down. Notice by of aid interim order, it is provided that if in the pending execution proceedings, any measure is taken by any of the parties pursuant to the award of the arbitrator, the same shall remain subject to outcome of the.
That payment,
Subject
that, what
It's
I
only
come to guess.
scrutinizing, may I submit, my lord? It's more than 6 crores which we are claiming. The partnership firm has been dissolved unilaterally. So both the tribunal as well as the 34, they have held that it is wrongly done. Now I'm asking that money to be given to me, my share. So the court has only directed, appoint a chartered accountant and scrutinize the account and keep it ready. Once this is decided, my lord, my share I will.
No, my brother is rightly saying that is beneficial to you also.
Yes.
What I'm
Know where you stand.
what I'm thinking is this, if the auditing is fine, it will be taken place, right, but giving into effect is a question, Lords may stay that,
Giving to-
subject result, giving into effect of that report, that could
It's
be.
only
Question of giving
scrutinizing.
it.
But
Prayer
payment
is
of money
clear.
would arise, that is what reason.
Prayer is clear, my
It's
lord.
not that.
Don't advise, don't invite any observers.
Yes.
Don't invite any observers. That is better.
My lord.
We'll just issue notice and
Yes. Yes.
that's all.
He has to only give the accounts so that the chartered
We are not
account,
saying anything.
my lord.
We are not saying anything. The executing court will take.
Yes. Only accounts will be scrutinized, my lord,
So
subject to result of this.
we are not saying anything. It
Yes,
is
sir.
always subject to result.
Please, my lord, oblige, my lord.
Let But if it is given, some date may be given, because some date for
Date is.
records may be called for.
12th June.
Records may be called for.
Record and proceedings shall. We'll call for on that day. Let us.
Still number 26. Mr. Vikram Muni Rajgopal.
26, I
Appear
beg
for
to
the
appear
appellant.
for the first
Lord,
respondent.
My lord, I heard this matter on the question of banker's lien.
This
linger.
matter, yes. This matter,
And my
my lord,
lord,
there is one original application pending before DRT, my lords. I require a week's time, lordship's permission to produce some of the documents which is pending in the OA before the DRT, my lords, because one of the contentions which I argued in the last date of hearing was, my lords, I have paid the entire money to them out of a housing loan. Then, lords, they have failed to release the original documents of the housing loan. I have borrowed it from other bank and I paid the entire money. They have failed to release the original documents. Canara Bank has failed to release the original documents. Lords, on the ground that the first respondent herein has stood as a security has a guarantor in some other company, and I have already resigned from that company, lords. However, what was the amount due from that third party company, lords? They have initiated original application proceedings before the DRT. And lords, some of the properties of the original company were also attached, and some of the properties belonging to me worth about more than 20 crores have also been attached there. Apart from all those securities, where the outstanding loan in that OA is about 6 crores, and my properties itself about 25 crores have been attached, apart from the company's properties. All these are, lords, held by them as security or attachment towards that outstanding loan where I have stood as a guarantor, and I have already resigned from that company. Lords, that is being decided there. Nevertheless, lords, here I have paid the entire amount for my housing loan. I am only seeking for release of the original document. So I am seeking, lords, a week's time to produce those records where they have sought for attachment before the OA court. And they have enormous security, lords. For a loan worth about 3 crores, they are holding properties of about 25 crores worth mine, and also that company's property is worth about 6 crores. Apart from that, they are not releasing this. This, lords, this I have taken loan from some other third party bank and I have repaid it. Now that banker who has lent me the money to repay this, but they want me to surrender the originals. I am stuck here, my lords.
Well, none of these-
Any date next week or?
On the last occasion, I think my lords had asked the question as to whether the expression general account.
It can go to 7th April.
7th April.
7th April.
So 27, 28 are agents. Still number 29.
Great.
Mr. MC Basuraj. Still number 29. Mr. MC Basuraj.
No keeping back. There will be no chance to record. So let it go to 9th of 24th of April.
So 30 is agent. Still number 31.
What is that? Elephant?
Place. This writ petition was filed as a public interest litigation in October 2020, pointing out lack of education for the children who market these toys and balloons on the roadside. Then this honorable court felt, why its order dated 18/11/20, that the scope should be enlarged to the entire state and should not be confined to Bangalore alone. Then for on account of lack of
marketing towards the traffic.
then on account of lack of assistance from the authorities, this honorable court appointed the Karnataka Legal Services Authorities to give a report. They filed a report. The shocking thing was these children aged around 6 to 7 years, they are used for sex in the night. That is a report given by the police, by the Legal Services Authority. Then, since the matter involved certain discussions which could not be done in the open court, the court felt that the proceedings be conducted in the conference hall of this honorable court. Few proceedings were conducted, but suddenly it has again come back to the court. The very unfortunate thing is, one of the thing is, in an earlier proceedings, where this honorable court, speaking through His Lordship Justice K.R. Miller, as it then was, passed and directed that the entire amount collected as cess by the BBMP should be deposited.
Now, my lord, they have given the report that they have been depositing. What they have done is, arrears alone is being deposited, not the current one. Suppose, my lord, under the BBMP Act, my lord, there is a circular also, my lord. Suppose they collect 10,000 rupees, I'm just giving a figure, my lord. Then around 1,000 rupees is to be given as cess for the that's a child relief committee. That's beggars. They look after the beggars, my lord. And out of that 1,000 rupees, they can keep 10% as their administrative charges. What was noticed by this honorable court is entire 10% is followed by them. Whatever to be given for them is also there. Then this honorable court passed that they must give that amount. And now, my lord, the government advocate, they have filed a report on 28-24. Throughout the state, my lord, this is going on. They are not depositing the amount due for the concerned department, and they are keeping the money. Even now, there is, suppose they say that they have collected 1 crore today, that entire amount is kept with them. You know, that's what they have given the report now. From the report, is not my statement, it's their own statement. So two major things is, one, whether the cess is being deposited to them. Second is, what is the status of these criminal actions were initiated? And in fact, it has become an international, interstate thing also. Madhya Pradesh police are also involved. They are also taking action. But the police here, Miller, they are not taking action. When the district judge called him, Miller, he said, don't disturb me in the night. While giving his all, that's all part of the record, Miller. That's why, the court felt this matter should be gone in detail in the conference hall, instead in the open court. I leave it to the courts, Miller. There is a judicial order, Miller.
Lords, I appear for the Legal Services Authority, my lords. On behalf of the Legal
Camera.
Services Authority.
Take up in conference camera.
I'm sorry, my lords.
Will take up in the hall, not in the open.
Please,
From there.
please.
First week of April for the time being.
Please.
For camera. Let us go. Time for- You have to devote at least 1 hour in the conference.
That's
Will derail the
shortage of time.
functioning. Anyway, we'll do it. This is of which year? 2020. For the time being, 4th of April.
Please. Grateful.
Seal number 32, Rajesh G. Bhatt.
Hearing the applicant. My lord, I'm
My lord.
the son of the deceased R6. I filed an application for impleading to bring me on record, my lord, which I filed an application for impleading to come on record, my lord, in place of deceased R6, who is none other than my father. And Rule 25A entitles me to make an application, my lord. 19C. When my lord, 25A. 25A.
My lords, I have no objections to the impleading application.
No, last time also it took time for objections. What objections he can have? My lord?
Who has died?
Statute. I'm one of the applicant. He is also 2 applications were there, my lord.
You are the petitioner.
I am the petitioner, my lords.
You are the applicant.
Yeah, I'm the applicant for impleading. R6 died. R6 application was pending. R6 died. I'm his legal representative. I filed an application to come on record as LR of the deceased R6.
Where is that application? The IA number?
IA number, my lord.
One of 20. No.
Yes, one of 20.
19 capital C.
19 C, sir.
Capital C, not 20.
No, not one of.
19C, your lordship, I kindly say, my lord.
19C, you read, seen.
Yes.
Rule 19.
Yes, Rule 19.
Where is your application?
Application, my lord, I have filed it on
7th of February.
7th February. It's there on record. It has come up once. He took time for filing objections. He has not filed any objections. I'm ready with the main also.
My lords, may kindly place it for arguments, my lords. The petitioner has
We
engaged.
grant the impleading application. He is entitled to be there as of right.
Yes, as matter of right, I'm. IA 1 of 25.
So your father had made an application.
Yes.
IA number 1 of 25. Lord Learned Advocate Mr.
NK Ramesh.
N.K. Ramesh for the applicant,
Respondent number 1 to 5, man.
the Harish for the respondent, state and learned advocate, so and so was original petition. By filing this application, one Lakshmi Narayan Swami, M.L., son of late Lakshmappa. Respond number, your response was 6. Original number 6 has agreed to implement himself in place of deceased father. As this 6 stated that the father died on, that response's father died on 17/12/24. It was stated that the applicant is sole legal heir, capacity of the only son, and is entitled to common record, the very subject matter of leased land, or leased land is applied by the, was applied by 6 to be granted. Learned advocate for the applicant. Mr. So and so relied on provision of Rule 19C of the Karnataka Minor Mineral Concession Rules 1994 to submit on that basis that the applicant son is the only legal heir, and therefore as of right he is entitled to seek the grant of co-release, and therefore and that he was entitled to grant of co-release, and therefore as of right he is entitled to be brought on record. Present proceedings, paragraph. In the aforesaid view, and further in view that the petitioner is directly interested in the subject matter and the outcome of the petition, is a proper and necessary and proper party. Full stop. The present application is granted. The applicant so and so is permitted to be implemented as respond number so and so.
It will be 6A, my lord.
6A. Full stop. The cause title of the petition will be amended accordingly. Application is granted. The cause title of the
Since it's already
bringing on record the applicant as the heirs and legal representative of deceased 6.
well, since application has been granted in my favor, he has obtained a stay. From early date, my lord, he has obtained a stay of the order.
28th of March.
Please.
Grateful. Appeal shall be registered on 28th.
Number 33. Sir Ramesh Nayak, L party in person.
I am the petitioner, my lords. Matter pertains to protection of lakes, my lords.
Your file reply.
My lords, regarding the prayer number 1, protection and preservation of Maidala Lake surrounding Tumkur city, my lords. It's been 2 years since the notice has been served, my lord. They have not taken any action, my lord. Even a deputy commissioner.
They'll file reply. Reply shall be filed within 3 weeks, 10 or 2.
Great.
11th of 13th of.
And one more thing, my lord.
June.
My lord, one more thing, my lord. Regarding the prayer number 2, my lord. My lord, one more submission, my lord. Regarding a prayer number 2, my lord, there is no authority in a state to maintain a full list of all the lakes in the states, my lord. So I have
after they file reply,
that is regarding the prayer number 1, my lord.
After they file reply, we will consider.
Because on the last occasion, I filed an IA to bring tank conservation authority on records, my lord. So that has not been taken into consideration, my lord.
Everything at a time.
34.
Grateful.
Rohan Kothari.
Your Lordship, this is a matter pertaining to a demand made for payment of arrears of royalty in relation to excavation of ordinary building stone under the Mines and Minerals Concession Rules. The notice issued, Your Lordship, is at page 31. If I could draw Your Lordship's attention. It is a notice made on the 17th of March 2023. I had moved Your Lordships immediately upon receipt, but the matter could not be taken up on successive dates. The notice is issued in furtherance of a rule, Rule 6.3, which says that prior to making a demand of payment, I have to be heard. And the maximum punishment for a breach that's possible is 50,000 under that rule. However, without being heard, Your Lordship, without being given a notice of being heard, a demand is put for a sum far exceeding what the rule permits, 11 crores. And Your Lordship, in similar circumstances, this court has found that this notice be treated as a show cause notice for me to reply.
Order is there.
Yes, Your Lordship, 2 judgments. Your Lordship will have paragraph 3-4 onwards. Identical circumstances. Give me a call. In the first judgment, Your Lordship, Nagesh Sallan, paragraph 4.
Yes.
My lord, previous
No
notices
notice,
were-
no adjudication.
No, previous notices were issued, my lord. In fact, the audit report was also given. We have filed a statement of objection.
Is there any quantification process done?
No, my lord,
Process of quantifying the penalty.
please, my lord, there was an audit report also. Kindly see the statement of objection.
Have not been served.
Earlier notice was there.
Even the earlier notices is not a notice to come forward and explain. It is a notice to pay.
16/8/22.
Yes, Your Lordship. That is at page 48. Your Lordship may see, this is the first notice to me. At the bottom of that notice at page 50, the above entire arrears shall be payable. No notice for me to reply, no notice for me to come forward and say why this breach is not actually taken. Without hearing. And Your Lordship, if I could draw the court's attention to the rule.
Did you reply? Had you replied to this 48 notice?
My lord,
Your Lordship, I have replied. Your Lordship, I'll place that reply also on record. I had in fact replied to No, Your Lordship, I stand corrected. The reply has not been placed on record. I have only placed on record a letter a little bit earlier in time at page 105, saying that I have paid royalty in excess of what I am quarrying. And that, Your Lordship, is a letter Your Lordship will find at page 99. At page 105, my apologies. I pay royalty in advance of quarrying to an extent of almost 6.5 crores. They carry out an inspection and find that there has been some transport of mineral without an adequate permit being issued or being secured. And immediately thereafter, they issue the demand letter at page 48. The law provides, Your Lordship, for me to be given an opportunity of being heard. And the law stipulates that the maximum penalty for such a breach is at 50,000 rupees.
Which section?
Rule 6.3, Your Lordship, of the Minor Mineral Concession Rules. This is the rule under which they have issued the notice to me. May I read, Your Lordship?
Subsection 3.
Rule 6.3, Your Lordship. In case of
Overruled. Yes, 25,000. Within such period, fine. Read it.
two violations, Your Lordship, no opportunity, and maximum breach fine is 50,000. They far exceeded what they've asked.
Not only couple of submissions, my lord. One is that he has a revision remedy, my lord, under 53. There's a remedy of revision available to him under 53, Rule 53. Second submission, my lord, page 4 of my statement of objection may kindly be seen, my lord. They have not filed any annual or monthly returns as required under the statute, my lord, the relevant rules. There has been illegal transportation of the minerals, my lord, in respect of which an audit report was conducted, my lord. Several notices have been issued, my lord. Page 5 of the statement of objection, small Roman 3 may kindly be seen, my lord. These are the notices which have been issued, my lord. 5,05,054 metric tons, my lord, totally has been extracted, my lord. Out of which illegally transported is about 2,76,589. An audit was conducted, my lord. Inspection was done.
Then all is without hearing.
No, my lord, para 3 of my statement of objection, my lord, small Roman 3, my lord, page 5, my lord. Para 5, small Roman 3, my lord, at page 5.
What do you say?
My lord, we have stated the petitioner has suppressed the fact that for the year 21-22, notice of demand dated 17/3/23, 28/12/22, and 23/11/22.
Where you are reading?
My lord, page number 5 of my statement of objection.
Oh, yes.
Small Roman 3 at the bottom, my lord, last two lines. It starts from the petitioner has suppressed the fact that for the year 21-22, a notice of demand dated 17/3/23, 28/12/22, 23/11/22, annexed as Annexure A to C to the present writ petitions were issued for a sum of rupees 11 crores on dot, along with applicable tax. The said demand was preceded with an intimation transportation, my lord, without the permit. Not responded, my lord. He has a revision remedy now.
Revision only will lie on an order passed, Your Lordship. No order has been passed.
It is available.
Revision is available. Rule 53, it is covered. Connected judgments, I have similar cases, my lord. I produced that page number
Your Lordship,
21 to the
in
statement of
identical
objection.
situations, the judgments I have provided, the court has held, Your Lordships have held, that this is not an order that is revisable. It is a demand made in respect of which I have to be heard prior to a demand being made. Your Lordship will look at those two judgments, identical circumstances. And the remedy of revision is pertaining to an order passed, Your Lordship. There is no judicial order or quasi-judicial order passed. And I'm not stating don't hold me accountable, but give me an opportunity of being heard.
My lord, the page number 21 of the
I could request for a moment, Your Lordship, the court's attention to the judgment of 2018. The first judgment. May I read it? This is the one. It's a short judgment, Your Lordship.
Nagesh Salim.
Yes, Your Lordship. Paragraph 2 onwards. Petitioner said to be leaseholder of so-and-so, located such and such, has preferred the writ petition being agreed of notice, as I am, issued by the respondent to where a demand is made
of such and such amount being the arrears of royalty on the allegation that petitioner is not having obtained mineral dispatch permits. Same allegation as the one against me. The government pleader appearing for the respondents, though attempted to justify the action, but could not dispute the fundamental fact that before calling upon the petitioner to remit the amount by way of an impugned notice, the petitioner was not served with the prior notice of demand sought to be made. It is in the indisputable fact situation that the impugned notice has been issued without extending an opportunity of hearing to the petitioner, which is what the rule provides, Your Lordship. We are of the view that the recovery cannot be sustained. In our view, the interest of justice shall be served if the notice dated so-and-so is treated to be a show cause notice, and the petitioner is permitted to submit his specific reply to the allegations made within 4 weeks. Upon receipt of the reply, it is permissible for the authorities concerned to take such appropriate action and to pass a speaking order within 90 days. Against that speaking order, yes, I will have a remedy of revision. But right now, I can't.
What is the 16/8/2022 letter of demand?
Your Lordship, there are successive letters of demand issued. 16/8 is the first letter I have received.
No, where is it?
That's at page 48, Your Lordship. Page 48. And Your Lordship will look at the language used. They don't say come forward and explain. They say pay. Page 50 at the last paragraph.
Where is the notice giving an opportunity of hearing?
My lord, these are the notices, my lord, that is available on record. Page number 48, followed by page number 41, my lord. These two notices of demand were issued, my lord, followed by.
I would not make the submission if I had a notice of that nature, Your Lordship.
The same line. We'll dispose on the same lines. Same lines of this Nagesh.
I'm deeply opposed.
Number 35. To Sharon Desai AM, 14%.
Lord, I'm the petitioner, appearing as a party in person. My lord, this matter has been already noticed. This is regarding the temple in, it's called the Dattatreya Temple, located in Gangapur in Kalburgi district, my lord. This is one of the most important religious place, and there are many devotees come to this temple, my lord, and many devotees donate money to this temple, my lord. But unfortunately, there is nothing in this place, my lord. There is no basic amenities, no drinking water, no public toilet, no infrastructure is developed. And this temple is located on the Bhima River, my lord. So what I'm suggesting, my lord, I mean, just my thing is that this can be developed in public-private partnership, my lord, because there are many devotees outside this country are donating money through the website to this temple, my lord. If you kindly see the annexure.
Yes, I'll reply.
Your Lordship may kindly see the respondent number 2.
Part itself, I'll reply to the next page put upon.
Lord, it is for this. It is for the state. It is whatever.
My lord, respondent number 3 is the chairman of this trust, my lord. He's under the state government, my lord.
After you file reply, we'll consider appointing some amicus. Yes.
Number 37.
Much obliged, my lord.
B.S. Nagraj.
Now today, I'm filing a counter. I'm sorry, my lord. So this honorable court directed me to file counter.
B.S. Nagraj.
I'm filing counter, my lord, along with the documents.
Reply, where is reply?
I'm sorry, my lord.
Don't give him copy today.
Lord, it is not a public interest litigation, my lord. It is a personal interest litigation suit has been filed against petitioner and decree was passed, then the decree did not question before any appellate court that reached finality, then one more suit has been filed against the public servant, that is DC and others. The petitioner want to form public road in my land.
Now I am receiving today at 12:30 I have received the counter.
And
I will
also,
file my
Your Lordship,
rejoinder.
kindly see,
I will file
in-
my rejoinder.
in the suit,
Statement of-
application has been filed for litigating as a public interest litigation.
You have served today. Learned advocate for the petitioner wants time to file rejoinder application since the reply is out today only. Stand over to 17 June.
Date.
38 with the Preeti case.
Date.
Still not over.
It is over, my lords. It is all over. But there are two or three things I would like to say. One is that the commissioner has right now deleted all the databases without informing whether the councils, number one. So he's filed initial report, he's filed it and signed it. And another matter that was pending before about the money point part which they're supposed to pay, it has been dealt with by a trial court. And third, the commissioner is quite expensive. So he may be discharged. Yes, my lord. We have paid him 11 lakh rupees until now, together both of us. There is one more report which needs to be filed by him. We'll file some other because we cannot afford him anymore.
Actually, neither of the parties can afford him. But
This is what happens when better sense don't prevail on the parties. It is you to enter into a contract. There should have been good faith.
I bow
You
down
should have
to that
conducted the
suggestion.
business and gone.
Yes.
My lord, I bow down to that suggestions, my lord, but ultimately it is for the party to accept what we are saying. And
We have tried our level best, my lord.
we as councils have tried our level best, my lord, but ultimately this is where we are.
And I have filed one more application for masking of the name of the parties because it's a service provider. If somebody sees contempt petition,
My lord, before going on that aspect, I have some submission to make on the report of the commissioner that has been filed. If my lords were to have the report, my lords, the commissioner on 23rd Jan decided that the testing has to be completed unilaterally. And after that, when we did further testing, a few small issues have been identified in the website. Now, the defendant had in fact agreed earlier that they will help us resolve the issues. My lord, to give a small technical background to why I'm making the submission, my lord, this website has been built from many years and it is the developer who will know the running of the website, my lord. As on this date, there are still a few aspects which are not working. And it will take only a couple of hours, if not minutes, for the developer to actually tell what has to be done to make it run. And all I'm asking was if the defendant could do that, my lord.
my lord, I would just like to bring your attention to page number 7
My lord,
of the commissioner's report. Page number 7 of the commissioner's report, my lords. The last paragraph. Page number 7. He says the defendant, Mr. Avnish, offered assistance in identifying the root cause of failures observed as he thought it might be due misconfiguration of the environment as it happened during the earlier testing 15. To my knowledge, plaintiff's team did not take him upon this offer. Even today, nobody from the complainant has reached out to us. My lord, what happens is they have absolutely no idea how the website works. So they are asking you to sit and go through the entire process of 10-15 years of development. That is not a part of the contempt petition, my lord.
My lord,
What they're expecting is completely out of the scope, my lord.
my lord,
of
it
this
is
petition.
not that we have not asked. We have asked. An email has been sent on 9th Feb requesting the party to help us. I'm filing that now.
My lord, that is not part of the contempt petition. My lord, we'll
If
cooperate
this
with them.
email may just be seen, my lords.
Yes. Come to page number 67. The order under contempt. That is the order under contempt,
Yes,
right?
my lord.
Come to page number 67, operative portion.
Please, my lords.
What are the directions given?
My lords, IA number 3 filed by the plaintiff, so and so.
Has it happened or not?
My lord, hosting back has happened.
Happened, okay. Then next.
I number 9.
Hmm.
My lord,
IA number 9 is on me, my lord. Upon hosting, I should not transfer the source code. That is upon
that they have not
hosting.
filed an affidavit yet. I do not know what they have done yet.
No, anyway, you're not on contempt.
No, not yet.
They have filed the contempt.
Yes.
Huh.
IA number 11, that also has happened, my lord.
Yes, that's it.
My lord,
Close.
IA number 2, if I may, IA number 2, the first point. That is for the defendants or anybody claiming under them restrained from tampering with plaintiff's website and its content, as well as restrained from shutting down and the website before transferring back the hosting services. I am on the point of tampering. I do not want to go to the extent of tampering and spoil what we have already achieved till date. I do not want to go till there. But as on this date, there are few aspects that are still not working, my lord. I have sent an email.
Does it amount to tampering or not?
My lord, we will know that if they help us and if it works or not, my lord.
Forget it. The onus is on you to prove it.
My lord, the defendant has agreed to help
No,
us. do
nobody
the
can
route.
satisfy you.
My lords, my only thing is the
You are not
website-
able to prove tampering, right? The onus is on you.
My lord, a 15-year-old website has been ordered for testing, and that too in the presence of commissioner upon the request of the defendant in 15 days, my lord, which was extended to 20 days.
My lord, the commissioner himself has not found any tampering.
15 years of development of a
This is
website has
only
been.
This is only about whether the workings of the website, my lord. It's not about tampering.
May I?
We are willing to
my
help,
lord,
my
you
lord.
have my email, and then
Where is the allegation of tampering from your side, madam, and where is the proof of tampering? Show it.
my lords, the defendant, since the defendant had agreed to help us with identifying the root cause,
It's your hunch that it is being tampered.
we have asked them to help us, my lord. They have not. I have sent an email on 9th Feb.
The onus is on you to prove tampering. It's not on them. You are alleging breach of the order passed by the trial court, right? You are alleging breach of the order passed by the trial court.
Please,
And you have filed this contempt petition.
please, my lords.
One portion of the order says that the website shall not be tampered by the respondent.
Please, my lords.
So to hold them in contempt, you are required to make an allegation of tampering on their part. And the onus of proving it is on you.
Please, my lords.
And we do not see any material in your pleadings showing that.
Please, my lord. May I, my lords?
Yes.
Lords, my pleadings, when the complaint was filed, tampering really could not be pleaded because we had no idea since the website was not hosted back. A website is an organic website, my lord.
If
It
you get the
keeps
proof,
changing.
if you get the proof, you are at liberty to file whatever you want in accordance with law and have it enforced.
My lords, my email may kindly be seen at least to show the kind of, they're very small, my lords. Instead of, it will take only a few hours for the defendant to resolve it, and it will take a year for me to actually go ahead and do this, my lords.
Has not entertained. Has dropped after this much exercise.
Disposed. Disposed as not entertained. It's dropped.
My lord, the masking and the discharge of the commissioner.
Pardon?
The masking of our names, my lord, because we are a service provider. If somebody does a Google search, if our names are shown, then we are not held in contempt. But our names may kindly be marked. In this case, a contempt petition, my lord. We have filed an application for that, to that effect.
Whose name?
The accused number 1, 2, and 3. Code Hall Technologies and Avnish Jain. They are service providers, they are engineers. My lord, it is done by this honorable
That
court.
can't be done in contempt proceedings.
No, but we are
You
not-
make that necessary application in the civil code if you require or some other place in accordance with law.
But our name will be reflected in the contempt petition here, my lord. It's a submission I'm making, my lord. I leave it to your lordships.
Yes.
My
so
lord,
much. The commissioner will be discharged because there is another part of commission which we have to get it done. We really can't afford him. Request.
Commissioner only for this purpose.
Yes. May it be recorded, my lord. Watch out.
my lords, compliance was done during the proceedings of this case, my lords. Compliance after filing of contempt upon directions by this honorable court, compliance was done by the defendant. I just wanted to.
That all, narrate the thing, if at all necessary.
Yes, ma'am.
The entire exercise is on record, whatever is done.
Watch out.
Number 39,
Oblige, my lord.
Mr. Master RK GMM Swamiji party in person.
I appear for the respondents.
My lords, I want to seek the remedy on administrative side, my lord. I want to seek the relief on administrative side, my lord. In order to seek the relief on administrative side, I have to
Argue
reply
on
the
that.
reply, my lord.
You can't
Reply,
argue on
reply of R1, my lord.
You can't argue in such a fashion that I want relief in administrative side.
My lord, my lord.
You are a responsible judicial officer. We won't entertain such a contents in court, open court of law.
My lord.
You approach wherever you want to approach. Mr.
My lord, IA2 is filed.
Be discreet in your submission
My
and
lord.
statement in open court.
Kindly order on
If you want
IA2.
something on administrative side, make an application, not here. No
My-
such submission on judicial. No,
My lord, IA2 is filed, my lord.
no.
My lord, I want to
such
delete
Such
the additional prayer, my lord.
Such is rejected.
My lord, please, my lord. Order on IA, my lord. Please, my lord.
Right.
My lord, I want to seek the relief on administrative side. Therefore, I have to comply the reply given by R1, my lord. R1 has given reply.
Which
There is a
IA
pending prayer. Please, my lord. Why, my lord?
Which IA you have filed?
My lord, IA2/25, my lord. I am seeking the permission or allow me to delete the alternative prayer, my lord. It is made in the appeal, my lord. I have to delete it, my lord. In order to seek the relief on administrative side, my lord. Please, my lord. IA2, my lord. IA2 of 25, my lord. My lord, IA number 4/25, the copy of reply given by R1 is filed, my lord. Please, my lord.
So you want to delete the alternative prayer?
Yes, my lord. Yes, my lord. That's all, my lord. That's all.
Where is that alternative prayer?
My lord, in the appeal memo, it is there, my lord. Alternative relief is there, my lord. I want to delete it. That's all, my lord. In the appeal memo, there is alternative relief. I want to delete it. That's all, my lord. Immediately after I got the relief on the administrative side, I want to withdraw the appeal, my lord. Pendants will be reduced, my lord.
Where is that prayer?
In the appeal memo, my lord.
Hmm.
I also prayed for alternative relief. Now, in your reply by R1, I want to delete it. That's all, my lord.
Which page?
My lord.
At which page your alternative prayer is there?
My lord, please, my lord. Please kindly allow the IA2, my lord, to make amendment. That's all, my lord. To make amendment, please kindly, I want permission of this honorable court, my lord.
At page 66, my lord. Ink page 66, internal page 53 of the appeal memo.
Yes, my lord.
Oh, he wants to delete the.
There is alternative. Yes, my lord. That's all, my lord. That's all, my lord. That's all, my lord.
Will permit it.
Nothing more, my lord.
He wants to delete a prayer, I have no objection.
Yes, my lord. Yes, my lord. It was also objected by the office, my lord.
2 of 25.
That's all, my lord. Please, my lord. Kindly allow the IA2, my lord. That's all.
Order.
Immediately after I grant the relief on administrative side, I will withdraw the appeal itself, my lord.
Order applicant petition.
Kindly allow the IA2 to make amendment. That's all, my lord. Amendment to delete the alternative prayer. That's all, my lord. Please, my lord.
Heard, learned. Applicant petition part in person. And learned senior Nagananda who appeared for video one for us.
First respondent.
Who is number 1?
I am complying the reply of R1. That's all, my lord. Please, my lord.
Where is your prayer of deletion? IA number?
I number 2 of 25, my lord.
2 of 20.
Application for amendment to delete the alternative prayer, my lord.
By filing this application, prayer is made by applicant part in person to permit him to delete the alternative prayer made in the appeal memo. First of the prayer which is sought to be deleted. Reads as under in page 65. Yeah. Pura. Full stop. It is the prerogative of the party as to which prayer is to be made and which is not, which is to be dropped. In view of the prayer made to drop the alternative prayer, the permission is granted. The said prayer shall stand deleted from the prayer clause at the cost and consequences of the party in person. Full stop. Application is allowed accordingly.
My lord, earlier it is ordered, my lord, all the interim applications shall be considered along with writ appeal. When it is heard, it may be recalled. That's all. If it is necessary, that's all. If it is necessary.
Mr. Nagananda, when shall we hear it?
Necessary, then it may be recalled. That's all. If it is necessary, it may be recalled. That's all. I want permission to amend. That's all. Please, my lord.
We recall the
Yes, my lord. Please.
deleted the prayer, alternative prayer.
Okay. Please, my lord. Thanks.
IA is allowed. Sorry. Next.
Grateful, my lord.
Number 40. Yeah, Ganesh.
Date, my lord. Date, my lord.
Which date do you want?
Please, my lord.
Which date do you want?
Date, my lord.
You give, which date do you want?
After 2 weeks, my lord.
After 2 weeks. Already.
Please.
16th of April.
Please.
That number 40. Mr. K.R. Ganesh Rao. My lord, A3 is a statement of counterfeit of it. Just now I received my. I will reply. Maybe given time.
My lord, in this case that the bank has complied with the orders of this honorable court, my lord. All the 3 accused, they have filed the counter affidavit stating that they have complied with the orders of the court, my lord.
It is not complied.
Here only, my lord, that
So, de novo inquiry is to be conducted.
De novo inquiry is conducted. In that de novo inquiry, the documents which are sought by the petitioner was not furnished to the petitioner. So that is why, as per the directions of the court only, that document is to be given. Prime document, vital documents. Vital documents were not given.
That is the.
So that is why contempt petition is filed.
My lord, 3,150 documents was given and it was sent to his house. Because it was a double, my lord.
Whatever documents sought by the petitioner as per the orders of this court were not given.
Where is that order of supplying the document?
It is not.
No, it is in.
We can't add or.
That order is there, annexure A, my lord.
Improve upon the direction. Yes.
And the de novo inquiry conducted and punishment has also been imposed and the matter has been closed.
It is already over.
Already over. And
no, that order is there, my lord.
What
order is there?
On July 2024.
What punishment is imposed?
Dismissal.
Dismissal. Without giving the documents.
More than 10 crores.
You challenge it. It's not the subject of contempt.
No, here order is there. Order of this high court is there. As per the order, they have not given me the documents.
Let us.
So that contempt is there.
Sir, let us see that order.
Letter order is there, my lord. Annexure A, my lord. Page number.
Page number.
1 minute, my lord. Para number 1 minute, my lord.
Let me read the order, my lord. Order, page number 33.
You will find out.
Yes, ma'am.
1 minute, my lord. Page number. It is mentioned, my lord, KYC norms and things. Do you know?
You file compliance.
My lord.
Compliance if it is filed by you.
Yes, my lord. All the 3
compliance affidavit is filed by you?
Yes, my lord.
Where is that?
My lord, page number 32, my lord,
32.
32. Page number 32, my lord. After that citation, madam, the respondent bank is directed to redo the inquiry process from the stage affording opportunity to the petitioner to provide all the vital documents as sought for by him by conducting de novo inquiry after providing entire material to the petitioner in connection with the allegations made in the charge sheet and opportunity extended to the petitioner to cross-examine the star witness whose presence is much required to prove the allegation made against the petitioner. So these documents were not given, my lord. I have sought these documents. These documents were not given. These documents in respect of the loan accounts which are mentioned in the charge sheet. The title deeds and statement of account is also not given. Statement of account of loan that is also not given, my lord. And these are all the vital documents. I had everything to prove in the inquiry based on these documents which were not provided. So that is why I am aggrieved, and there is a contempt by the respondent banks, this accused. Vital documents, my lord. There is a clear-cut direction or order of this honorable court.
Did you ask for the documents?
Yes, my lord. Pardon?
Did you ask for the documents?
Yes, yes, my lord.
Where is that?
Annexure 1.
When was the de novo inquiry conducted? After filing of the contempt or what?
No, my lord.
During the
de novo inquiry order, the de novo inquiry has been started. And after this only contempt petition was filed.
Okay.
De novo inquiry, my lord, as per the orders of the court, the de novo inquiry was ordered on and a creative petition. De novo inquiry was ordered on 18/4/23. And then immediately that the inquiry was started. And in the month of July only, last July 24 only, punishment was also imposed after conducting the inquiry. In the inquiry, my lord, 3,150 documents were produced. And some documents which was requested, bank said, what is the relevance? Because in some cases, about 50 accounts say that mortgage is not there as per the bank circular, as per the government scheme. Then he says you produce that mortgage, you produce that legal scrutiny report, produce all those things. They said, please tell us what is the relevance of these documents. Bank has written. And then, and as per the regulation also, my lord, regulation is very clear that the regulation says, my lord, that wherever the documents, the defense is asking for documents, they have to mention the relevance. And my lord, documents, all the documents produced according to that counter affidavit filed, my lord, that accused says that documents have been produced, all the documents. Some documents relevance he has not told, that is why it was not produced. They have to tell. Otherwise, that everything, if you ask, my lord, that where is that question of producing?
My lord, page number 62, my lord. Page number 62, my lord. Document sought by me as per the court order.
Now, Mr. Inquiry is conducted, punishment is imposed. Now, if any grievance remains for you for in respect of inquiry or non-supply of document or non-hearing, you have to challenge it.
No, this contempt is there, my lord. They have contemptuously, they have denied me documents. That they have denied me the documents. And even during the inquiry, provisional pension was also not paid to me.
Did you raise did you raise that point in the inquiry?
Inquiry it is raised, my lord.
That you did not.
Yes, provisional pension is not paid. Even provisional pension
Provisional
ta-
pension has
Yes,
been paid
this
as
is,
directed by the court, my lord.
Kindly
These are
listen
all
before
listed.
some.
yes, my lord.
Did you tell the inquiry officer that these documents are not supplied with?
Yes, yes, my lord. Then I have written a letter, my lord. See,
Then
this
it is
page number 62.
subject is a good ground to challenge the inquiry.
No, I will challenge, but for this contempt, there is a, no contempt, they have made a contempt, my lord. It is a contemptuous act. If they had given me the document, which as per the directions of the court, I would have succeeded in inquiry. They have deliberately, wantonly, they have not given. Statement of loan account was not given. And documents, mortgage documents were not given. Deliberately, they have not given, my lord. I would have definitely succeeded in inquiry. Other defects are also there in the inquiry, but this is a vital defect, my lord.
The regulation, my lord. Regulation 610 of office.
Heard learned advocate Mr. So-and-so for the petitioner complainant and learned advocate. For the respondents. Respondents Canara Bank and its authorities. The operative part of the order dated 18th April 23. Passed by a single judge while disposing of the writ petition was as under. Court page 33. It is in this, after quoting, it is in respect to the above directions that the present contempt petition is filed. Paragraph. In course of the hearing today, paragraph, learned advocate for the respondent bank stated that in light of the directions of learned single judge, the bank conducted de novo inquiry as per the observations made, and that the inquiry has concluded with imposition of penalty of dismissal against the petitioner. Full stop. While learned advocate for the petitioner would submit paragraph that in light of the conclusion of the inquiry, the directions are complied with. From a learned advocate for the petitioner half, that during the inquiry, the material documents were not supplied to the petitioner, and that it was observed by the court by learned single judge for supply of such documents. Full stop. When the inquiry and all the stages of inquiry have been completed, comma, which was the operative part, remitting the matter to the bank to conduct the de novo inquiry, comma, any question of commission of willful contempt of court by any of the respondents does not arise. Full stop. If the petitioner has any grievance about the conduct of the inquiry, including non-supply of the alleged material documents, comma, the only recourse for the petitioner to institute independent proceedings to challenge the inquiry proceedings and the outcome thereof on the grounds which may be available in law. Full stop. Reserving such liberty for the petitioner, comma, if so advised, comma, these contempt proceedings are closed as not serving. Full stop. It is clarified that this court has not expressed any opinion on the merits, including the contention of the petitioner about the non-supply of the material document, for which the petitioner is given liberty in accordance with law as above. Contempt proceedings are disposed of in the aforesaid terms as not surviving.
I may be permitted to mention all these things in the.
That we have said. We have said it. All grounds. All.
Number 41, the PC Sunita.
My lord, I have filed the application for compassionate appointment, my lord. That was.
You filed the compliance report on 17/1/2025. Endorsement is issued at page 46, 31/12/2024, my lord.
My lord, kindly see, my lord, the learned single judge order, my lord. After hearing them, my lord, the order has been passed, my lord, directing them to consider within 3 months, my lord. After lapse of 1 year, my lord, they have not considered. But thereafter, I issued notice, legal notice to the accused, my lord. They have not even, they have gave replied that stating that they are processing the application, my lord. After yeah, notice was issued, my lord, this affidavit is filed by them, my lord. My lord, kindly see the order passed by the learned single judge, my lord. Page number 12, my lord. Para number 3, my lord. This court in the case of Srimati Bhuvaneshwari versus Puranik versus State of Karnataka and others, held that the married daughter cannot be discriminated in the matter of compassionate appointment and she would have to be treated as par with the son. It is also not in dispute that the pursuant to the said decision, the state has accepted the same and has also amended the relevant rules. In view of the judgment rendered by this court, cited supra, in impugned endorsement at annexure J and K cannot be sustained and the same is accordingly quashed. The respondent 4 to 7 are directed to reconsider the same, reconsider the case of the petitioner, notwithstanding the fact that the petitioner is a married daughter, and pass appropriate orders in accordance with law in the light of judgment cited supra. The said exercise shall be completed within period of 3 months from the day from the date of receipt of the copy of this order, my lord. Even the rule is already amended and it was in force, my lord. When the application, when the endorsement is issued, my lord, even the endorsement is already quashed by the single judge, my lord. So far, my lord, if they are not satisfied with the single judge order, my lord, they have to file an appeal, my lord. Even till date, my lord, they have not filed any appeal, my lord. Even they are not considering my representation also.
Lord's page 46 of the compliance affidavit.
Be prepared. You can consider.
I'll brief you.
Second April, third April.
Please, my lord. Please, my lord.
Serial number 101. It's a 230 matter. I am appearing for the petitioner. In the morning, my colleague made a mention because my senior sister expired in a car accident, so he's not in station. So he made a mention in a wrong serial number 73. The serial number is 101, my lordship. I have informed the opposite counsel.
70 was wrongly mentioned. 73 was.
73 for the matter that was mentioned.
73 don't enter. 101 you want.
101.
78, my lord. 2 weeks time for office objection.
101.
101, my lordship. My lordship have given a date on 1/4.
So it will go to 11th June.
My lord, serial number 78. 2 weeks time.
So after summer vacation. 17 June.
Obvious.
Third April.
Court officer? Court officer?
ಹೇಳಿ.
ಸರ್ ಇದು 230 ಲಿಸ್ಟ್ ಫಸ್ಟ್ ತಗೊಳ್ತಾರಾ ಸರ್ ಈಗ?
ಬಂದ್ಮೇಲೆ ಹೇಳ್ತಾರೆ ಮೇಡಮ್ ಯಾವ್ದು ಮಾಡ್ತಾರೆ. ಬಂದ್ಮೇಲೆ ಪರ್ಮಿಷನ್ ತಗೊಳ್ತೀವಿ, ಯಾವ್ದು ಬೇಕಾದ್ರೂ ಆಗ್ಬೋದು.
ಹೌದಾ? ಓಕೆ.
230ನೇ.
ಓಕೆ ಸರ್, ಸರಿ, ಥ್ಯಾಂಕ್ ಯು.
Your Honor. For WA 983 of 2024, the Form C must be reinstated and it must be listed for the grant of interim relief. You had suggested that I meet the office. The office is stated that you must issue the orders. That's why I'm here. With reference to the memo that I had filed on 23/9/2024 under Order 6, Rule 17, for the amendment of the prayer, I'm willing to set it aside as soon as the writ appeal is listed and the respondent issues the consent letter, so that I revert to the prayer prayed in the memo of the writ appeal.
Very well. Posted here today? Not posted, then where?
I met the registrar judicial upon your instructions for getting it listed. She stated that I must see you for the explicit orders to be granted by you, because the explicit orders to be granted by you, and had filed my written statements for your Honor's investigation about the erroneously issued Form C or changed Form C by the party in person committee report. So
it is for the court where you are appearing will decide.
The investigation must be conducted by your Honor, because the office says the orders have to be.
Whatever is required to be done administrative will be done. But rest of the things to be done by the honorable bench where you are appearing and where the matter is posted. We'll see what can be done. Okay. But there is no matter before this court.
Permission, Your Lordship.
Yes.
Item number 86. On 19/2/2025, after hearing sometime both the sides, Your Lordship directed the office to post this matter at 2:30 in the 2:30 list.
Which one?
86. But by mistake, it is not posted in the, it is not listed in the 2:30 list. Can we investigate order also? It was a specific direction.
What is it about? Delay is there?
The matter pertains to the conversion order, Your Lordship. Application was filed by the respondent seeking for conversion, and the land corporation, based on a complaint filed by some third person, corporation passes an order of status quo directing the deputy commissioner not to pass any conversion order. Based on that, an endorsement came to be issued. I approached this honorable court before the honorable learned single judge, and the learned single judge set aside the order passed by the corporation that it is without jurisdiction and contrary to the provisions of Section 95 of the Karnataka Land Revenue Act. And the direction was issued by for the deputy commissioner to consider the application and to pass conversion order. The appellant herein claiming to be the MAT, he claims to be right over that property. He files an application before the honorable learned single judge for impleading. That was dismissed without challenging that order, and by suppressing that order, he has filed an appeal, and government has given an undertaking stating that there was an.
What is the request?
My request is, Your Lordship, kindly have it at 2:30 after completion of today's please or tomorrow or day after tomorrow, because since from 9 years, my conversion is stalled without for this.
Conversion.
Conversion order of my property.
We'll take up. Let us see. If the time permits today, we'll take up. If it doesn't permit, then we'll see. Yes.
230 matters, seal number 95. Mr. Chetan V, it's a withdrawal of contempt. Mr. Chetan.
Appearing on behalf of complaint, my lords, we have filed a memo, my lord, seeking withdrawal since the matter has become infructuous. They have complied the court order.
Chetan V for the complainant, petitioner complainant, invites attention of the court to memo dated 22/11/24, which figures on record, in which it is inter-alia stated that the contempt petition does not survive and may be permitted to be And may be dismissed as infectious. In view of the memo, the petition is dismissed as having become infectious.
Number 96.
Complainant, my lord, may be disposed of, my lord. The complaints affidavit has been filed. It has been complied, my lord.
Learned advocate Ms. Swan fairly stated that the contempt petition does not survive and may be disposed of. It is accordingly disposed of, does not survive. Yes, next.
Number 97, Mr. B.C. Venkatesh.
Not appear for complainant. Last occasion, there is a direction to file an affidavit along with the complaints that they have claimed to be made.
We have sent the compliance affidavit for signatures, my lord. We are not listening. We have sent it for signatures, my lords. Kindly give a short date.
27th March.
27th March.
Number 98, Harish Kumar MS.
Appearing for the petitioners, my lord.
Pass over today may not be possible. We'll keep it on 28. Yes, next.
Interim order may be extended.
Interim order is there. In this contempt petition, writ petition.
No, writ petition.
Interim order shall continue to operate till the next.
Published.
Number 99, Mr. Kumar S.
So there are three matters. The latest writ petition is 4010. In this plot, the prayers are at page number 18. As your lordships might know, my lord, the act was amended once
stone crushers.
My lord, before my learned senior can begin, my lord, this pertains to a dispute with regard to the distance from the, my lord, major development road, my lord. My lord, there are three measurements that have been given. My lord, the first distance they say is 73 meters. My lord, the second they say is 35 meters. And the third they say is the 16 meters. My lord, if a fresh, my lord, survey could be done, and then if it could be argued, my lord, I think it would give a quietus, my lord.
What is to
Because a fresh distance we could measure and bring it to the notice of my lords.
So what is the ground distance from monuments?
No, my lord, from the crusher unit to the major road.
Major road.
Yes, it is beyond, it is a safer zone, yes.
Central line of the road.
Yes.
My lord, the rule requires that it should, the distance, my lord, rule 6 may kindly be seen. Kindly see the as amended rule, my lord. Section originally, my lord, Section 6B1, my lord, is the relevant one.
100 meters.
2020 amendment. This contemplates the determination of a safe zone. 6B, my lord, originally, my lord, 6(1)B, my lord, read like this. The safe zone shall not be located within 100 meters from the limits of major district roads or other roads. That was the rule, my lord, that was in force. My lord, at the time when my license was granted to me, this was measured in 2017. And there's a report of that extent also. And based on that, my lord, this was a declaration was made that my land is within the outside the safe zone. So, my lord, a license was given to me. There was a joint inspection conducted in 2017. There's no change in the land or the road. And in as per Annex Ready on 14/12/17, a notification is issued declaring this to be in safe zone. Thereafter, my lord, license is given to me in 19. I have been working under that license. Suddenly, my lord, in 2021, they institute a proceeding to say that this is not within the safe zone. In the interregnum, my lord, the law becomes, it gets amended in 2020. And the amendment does, my lord, is it incorporates two situations. One is 100 meters from the limits of major district roads and 50 meters from the limits of other roads. So that means two parameters are there now. It should satisfy both. 100 meters from the limits of major district road and 50 meters from the limits of other roads.
What is the other one?
100 meters from district major road, 50 meters from the limits of other road. Now, my lord, they initially give me a notice to say that this is within 73 meters. That was in the year 2021. They passed an order without properly hearing me. So the Honorable Court intervened, set aside that order and then said, please rehear them. Then, my lord, they issue a cancellation order again. That is again interfered by the Honorable Court, set aside. Then, my lord, they now come with a third inspection in October 21, saying the same land is now 35 meters. Now, my lord, in this interregnum, the term of license, my lord, has been amended. And as per that term, my lord, all licenses which were granted prior to the amendment, which were for 5 years, will stand extended to 20 years. So my submission is, my lord, that this should go, and my extension of 20 years, I am entitled to grant it, to be granted that. Now, my lord, another problem which has intervened is in the other batch of cases, your lordships may recall that the Dam Safety Committee, my lord, this is a stone crusher, it's not mining. But nevertheless, my lord, the blanket order that was passed in the batch of cases, my lord, said that the Dam Safety Committee must look into it. So when I go before the Dam Safety Committee, they say your license is not valid, so I'm not going to look into anything. In the
License was?
Not valid. License has expired. It was 5 years. The automatic renewal, which I am entitled to, they are not granted it because of these proceedings. Now my learned friend says they want to do one more measurement.
No, I just made a suggestion. I didn't say
No,
I
no.
want to. I just said I made a suggestion.
Okay.
The writ petition can be kept pending. Then my lord can, if my lord, a survey is done, my lord, a clear, my lord, outcome will be there, and then we can proceed. The license is already cancelled in the connected writ petition, my lord. So there's no difficulty with regard to that. In 99.3. And by way of an interim order, they are permitted to proceed with continue the crushing activities.
But I'm not able to, my lord, they have violated that order. I filed a contempt, my lord, to say that they are not permitting me to do my activity. Meanwhile, my lord, the order of the court regarding dam safety, that also is, my lord, coming in the way now. So I am actually closed, though there is an interim order. But your lordships may see, my lord, in this writ petition 4010, there is a inspection report that is submitted. That report, my lord, all the officers who are relevant to this have participated in that. I don't see, my lord, why there should be one more survey or one more measurement. Kindly see, my lord,
If senior doesn't want, then it's no problem, my lord.
writ
I
petition
was
4.
just thinking that to give it a quietus, keep this writ petition pending and my lord can give us some time and then my lord, we can arrive at.
Nothing wrong with.
My lord, what I'm saying is, my lord, there is record on record in 2017 by the competent authority. Kindly see the inspection note, my lord, and the government order that has been passed pursuant to that. In writ petition 4010, my lord, your lordships will get it at page number 28.
My lord,
There's
what
a-
has happened is, my lord, this road has been upgraded as a major district road. Because of which, my lord, we are having this problem with regard to the distance. So I just, my lord, made a suggestion, my lord, within 2 weeks or 3 weeks, and then my lord can hear this matter. There's nothing with that. Since there are 3 different, my lord, distances given.
Please see this survey, my lord. Unless, my lord, every time some new officer comes or for some other collateral reason, they cannot go on, my lord, troubling us like this. Please see, my lord, their own document.
Your license has expired.
No, my lord, my license was
Cancelled.
for 5 years. My lord, the original grant was for 5 years. The section was amended in 2020.
So you're claiming benefit of extension of 20 years.
Yes, that automatically the section says all those who are licensees, 5 years will become 20 years.
Suppose the expired license had to be renewed.
No, once it is cancelled, my lord,
What is the procedure for renewal?
my lord, they have to file it within 3 months, my lord, but
Measurement is part of the process.
No,
no.
Remeasurement.
no, my
No,
lord,
no,
the
no.
old
Measurement is
license,
not.
it said what the section,
No, in a given case, an expired license is to be renewed.
it's not, yes, sorry.
Renewed. Then what is the procedure?
My lord, in this case, my lord, what the law intervened to say, all those who are holding 5-year licenses, the period gets extended to 20 years. It's not a renewal at all. The term, my lord, of a statutory lease automatically,
This is not a renewal.
it's
but
not
in
a renewal.
In a given hypothetical case of simple renewal,
Yeah,
after expiry of the period.
Yeah.
What is the procedure?
My
The
lord, before
procedure-
expiry.
The procedure will also contemplate the remeasurement. Rest.
No. My lord, my submission to my lord is,
Why do you insist?
my lord, my submission to my lord is because this was upgraded as a major district road, my lord, it fell short of 100-meter safer zone and we were constrained to issue a notice, show cause notice. My lord, the reply was considered and then it was cancelled.
that upgradation happened in 2007.
Maybe
So
that was.
that is also taken into consideration in the last measurement. There's an order issued, my lord.
Page.
My lord, please go to page 28 in WP 4010, my lord. This is the joint inspection conducted. In the first column, your lordships will have the name. Third column is the survey number.
Page 30.
28,
20.
annexure B. It's a typed copy, my lord, of the manuscript in Kannada. The first column, my lord, is name, then village, then survey number, then patta land, extent is 2 acres, then details of quarry lease, it says no information there. Then the exact area, my lord, in terms of geological situation, the measurement, that is a Google point is noticed. Then conditions. It should not be within 200 meters from national highway, not be within 100 meters from main district road or edge. Then present distance, 5.7 kilometers from state highway, 101 meters from Basti Alli Kaveripura road. And last column, opinion. Department of Mines and Geology complied. Rule 6.1, it can be declared as safe zone. Revenue Department, section 6.1 is complied. And this is signed, my lord, please see. Senior geologist, he is the appropriate authority.
Where's the English?
Tahsildar, next page, no, 29. Range Forest Officer, Environment Department, Pollution Control. Exact measurements are given. Forest Department has cleared it, Environment Department has cleared it, Revenue Department has cleared it, Geologist has cleared it. And pursuant to that annexure C, the English version, my lord, is at page 33. A notification is issued by the competent authority. I am operating in terms of this. The authority which issues this is a party to the writ petition also by office. Kindly see, not page 33. This is in 2017.
Now it is district road or state highway or national highway?
No, it is a district road only, major
Also.
district road. Yes.
My lord, I have produced an extra R5 in my, no, if my lord is hearing the matter. My
Yes,
lord, my
for
lord is
hearing.
hearing the matter, my lord wants us to, very well, then, no problem.
Now the question is it adjoining a district road or a state highway or a national highway?
In my statement of objections in WP 9037 of 2022, my lord, I have filed annexure R5.
Don't have that. You don't seem to have that. No?
My lord gets it, page 33. My lord, please see the subject. My lord, and in 1, 2, 3, 4, 5, 6, distance between the district main road and the crusher unit. My lord gets it as 30.
So according to you, it is 30 meters.
Yes. This is given by the Assistant Executive Engineer, PWD. 18/10/2021.
This objection, what they have found, shows that it is 30 meters. Distance is 30 meters from authorities. The transcribed road. No. Some people could be person.
No, there's an interim order granted after hearing.
This objection because you have not filed it in the instant writ
No,
petition.
no, we have, my lord, I have a copy also of acknowledgement. And I'll provide a copy, my lord, there's no problem.
See, if you can see this objection, the measurement says 30 meters.
Yes, my lord. In fact, I have produced that inspection, my lord, annexure P, which is 27/10/21. Is that the same one your lordships are producing, my lord? 27/10/21.
Annexure?
In my writ petition, it is annexure P. That is, my lord, in WP 9037.
Page number?
Page number, my lord, 109. The Kannada version, English version is 110.
The writ petition is only 77 pages.
9037. Writ petition 9037. Page 110. Typed copy of translated typed copy of annexure P.
Yeah, same thing.
Same thing. This I'm aware of.
My lord, in B.
Now, in fact, this honorable court, my lord, took notice of this divergent viewpoints and granted an interim order. Your lordships may please see the interim order.
I think the best thing would be to measure afresh, probably.
No, my lord, I would submit like this, my lord. There is already a measurement done. From
No, sir, this is
2000
also a measurement, no.
No, 2017, measurement is done. And
Correct, but later on again they have measured and they have submitted a report which says
whether they
35
can do
meters.
that, my lord. Whether they can do it every time somebody
No harm
wants to
in,
trouble me.
no harm in going with the factual.
No, the harm, my lord, is this, my lord. I'm a licensee. From 2019, I operated. Suddenly, my lord, in 2021, they issue me a notice to say it is 73 meters. Then, my lord, those proceedings, my lord, successively this honorable court has quashed. Then now, when at that stage they come up with another measurement in which they say 35 meters. Now, my lord, they say, if you want, we'll do one more measurement. And my submission, my lord, is this honorable court took notice of this and passed an interim order to say they're not clear. They've got 3 measurements they're given. Therefore, we are going to stay this. Your lordships may see the interim order granted. After taking note of all this, now, my lord, it suits their convenience to say we'll do one more measurement. Now, if supposing that says, my lord, it is something else, then where will it stop? And now, my lord, your lordships may also consider this. What is the power of this authority to continue to revisit this? There's no power of review. There's no methodology by which they can undo what they've already done and granted me the lease under which I've operated. Now, because somebody doesn't like me or for some other reason, they institute proceedings like this.
In
My lord,
in absence of any contrary material, counsel is right.
my lord, then, my lord, in that case, since this order is appealable.
You don't have anything to show that why you want a fresh measure.
No, my lord, it is not
Except
that.
saying that there will be cause no harm. That may be all right, but then why should repeated exercise? That is also a valid aspect.
My lord, mine is also a point to give it a quietus. That is all. I didn't want anything. If they want to argue, fine. My lord, this order is appealable under section 15. Let them go before the regional commissioner and let them thrash it out, my lord. At least the regional commissioner will know as to what the officers are up to.
Section 15
of the Crushers Act.
Lord, rule has been issued in this case after hearing, my lord. Now, alternate remedy is not an argument which they can canvass.
No, but considering this is a case that
yes, my lord.
facts are involved.
Even if rule is issued or appeal is admitted, that, and even if point not kept open, the court can.
But my endeavor, my lord, is to make a submission that in the facts of this case, my lord, please see, my lord, how they are trying to, my lord, undo everything that has been done. There must be some finality to administrative decisions also.
Let us hear.
They kindly peruse your lordship's order, my lord, of 28.
My lord, I was just trying to be fair, my lord, and saying that we are trying to do this, we are trying to do that.
Nobody is unfair, but let us see what is the order.
The order of 28/4/22, my lord, of your lordship's, my lord, in
422.
Yes, in this 9037. When they issued me the notice in 21, the 3rd paragraph, in the order dated 31/7/21 at Annexure K, the authority has opined that the distance between the land in question and the district major road is about 73 meters. However, there's another report dated 27/10/21 wherein it is stated that the distance is about 35 meters. Therefore, there is some confusion even in the mind of the respondent authorities. The matter requires reconsideration and factual information is required to be secured. In terms of the amended provisions of section 616, the prohibited distance is 50 meters. Should be 61B.
Sir, what are you reading, sir?
This is the order dated 28/4/22 in writ petition. The interim order. Learned counsel for the petitioner made out of prima facie case, consequently led by an interim order of stay of operation or execution of the impugned order dated 31/3/22. That is the impugned order before your lordships.
I filed, my lord, my statement of objections in 9037 of 2022. My lord can take from paragraph 6. My lord, with regard to maintainability, I have said that it is appealable under section 15. And then from paragraph 6 onwards, my lord.
So prohibited distance is 50 meters from any road.
Any road, since this has been upgraded as a major district road, my lord, we were constrained to issue a show cause notice. We considered that
The order said that any road, any
road,
Any
but this is the district major road. It is 100 meters.
But after this interim order, the matter is again heard by your lordships, my lord. And by order dated 21st February 23, the Honorable Court, my lord, noted, Honorable Chief Justice, my lord, sitting in this court, peruse the documents placed on record, matter requires consideration, issue rule. This is the order, my lord, dated 21/2/23. And a further direction is given. Division bench of this court, by the order, granted interim order, same is continued and extended. Respondent authority is directed not to cause any hindrance to petitioner's functioning of stone crushing activity. If such hindrance is caused by blocking integrated lease management system, same be restored. This was challenged before Supreme Court. Honorable Supreme Court declined to interfere.
You also remain present when measurement is done.
No, that is the ultimate thing which can be done, my lord, but what I'm submitting is this, my lord. In a case like this, should there be one more measurement at all when there is unless they show, my lord, that there's something wrong with the 2017, no proceeding is there. Independent of that, my lord, they suddenly start a proceeding in 2021. And the Honorable Court has noticed the variation. It can't, if it's a few meters, I can understand, my lord. It can't be.
Sir, the observation in the order is the matter requires reconsideration and factual information is required to be secured.
Yes.
So that is the order passed on
Yes, ma'am, I have that.
28/4/22.
Yes.
So this court on that day also was of the opinion that factually we need to know what is the distance, which is not stated to explicitly in the objections filed by the respondent. That's why this confusion has arisen. So to put it at rest, there can be a joint measurement. You also remain present. If there is any factual errors, you can raise your objections.
My lord, I would respectfully submit like this, my lord. There is a measurement in 2017 that has been acted upon. License is granted to me. They are not cancelling my license on any violation of the terms of license. They are now inventing a new reason. No, my lord, are they
Sir, it
permitted
may
to-
be a genuine mistake committed on their part.
That's not what they're saying, Lord. I can understand, Lord. I can understand. If they came up with a show cause notice to say that there was a measurement in 17, the following officers.
So to put everything at rest, is it not the right methodology?
Lord, I would respectfully submit, my lord, that government cannot go on prevaricating like this. After there is a record, if there is fraud, let them allege fraud against all the officers who are present there. Or let them hold inquiry against them, do whatever they want to do. But they can't, my lord, say, yes, there is a measurement and the license is granted by the government. After that, my lord, there's a first notification that's a safe zone. That is notification not challenged. That notification remains 2017 notification. Till now, they have not said even in 2021 that that notification is fraudulent. It is illegal. Therefore, it should be undone. They can't, my lord, go on like this. And the amendment will not vest certain rights in me automatically. So they don't want me to.
It's cancelled. It's cancelled.
Extends for 20 years, he is not.
It's cancelled. Now with the my lord, the directions of this honorable court, they were permitted to work, and my lord, as my learned senior rightly said, because it came within 20 kilometers of the KRS dam, my lord, they have not been able to quarry. Implementation of the order has been stayed.
This is correct.
Pleadings are complete.
Madam?
Pleadings are complete.
Yes, yes, in
Pleadings
that
are-
pleading.
pleadings.
Yes.
Then let us start.
Lord, please take 9037.
Nine zero three.
Lords, please take 9037. The prayer is at page 24. First prayer is to call for records, and 2 is to quash annexure A. Passed by third respondent, cancelling license form C granted to petitioner. The Lordships will have, my lord, the order at page 27. The English version is at page 36. Lord, please notice at page 37, they take note of this 20-year extension on top of page 37. The crusher license form C was granted to Mrs. Prabhavati Stone Crusher for a period of 5 years, except from 2 to 19, in respect of Patta land bearing survey number 117/2, measuring 2 acres, situated so-and-so village. In terms of section 5.2 of the Karnataka Regulation of Stone Crushers Amendment Act of 2020, the period of license was extended up to 20 years from the date of original grant. Then, my lord, next para, they refer to the 2001 notice, 2021 notice. And the allegation there, my lord, was a senior geologist brought to the notice the meeting of Mandya District Regulation Stone Crushers Licensing Authority held on 16/4/21 that the district main road is situated within 100 meters radius, and it is noticed that before declaration of safe zone in 2007 itself, the road upgraded and section 6(1)(b) of the Karnataka Regulation of Stone Crushers Amendment Act is not complied, and issue a show cause notice to licensee on 23/4/21. Why your collecting license should not be sought cancelled, and sought explanation. Then, my lord, the further proceedings, my lord, in different courts are noticed. At page 38, they passed the order. Then, my lord, there's a writ petition filed. And the writ petition was allowed at page 39, middle of that page. If they aforesaid, the petition stands allowed. In the light of the order passed in WP 14795, the other connected petitions also allowed. Impugned orders are quashed with liberty to respondent to issue a fresh show cause notice to petitioner in each of the writ petitions, granting 15 days time to file objections. Thereafter, competent authority and the act who has to issue notice shall take final decision. Then, my lord, one more notice is issued asking me to appear before them. At page 40, my lord, our submissions are noticed. And at the first para, my lord, I say that earlier it had been granted. I have been running the unit. In second para at the bottom of page 40, the entire basis for the show cause notice is completely not in existence in the eye of law. The notice is tainted with malicious and only at the instance of certain vested interest, such kind of notice is issued. It is unfortunate to notice that officials, even without considering the ground reality, is acting at the instance of politicians who are out and out to destroy the entire business activity of all persons who have invested huge sum of money. Therefore, the notice issued is illegal without authority of law. Then, my lord, next page, I reiterate the same thing in para 3. In para 4, my lord, I point out that the proposed cancellation has no legs to stand in the eye of law. It has been amended. The distance has been reduced to 50 meters. Amendment to section so-and-so is enclosed. Then next page 42, my lord, he refers to the personal hearing. At bottom of page 42, last paragraph. In terms of the orders, hearing dated 8/10/21 and 21/10/21, as per joint inspection of Revenue, Forest, Karnataka Pollution Board and officials of Department of Mines Geology conducted in the presence of licensee of crusher unit under section 6(3) Regulation Act in respect to the land measuring 2 acres, informed that the said crusher unit is situated approximately 35 meters distance from the district main road of Pandavapura to Chinnagurali via Bethalli, etc. Further, the assistant executive engineer, PWD, in his letter stated that the said order as per government order dated 11/5/2006, dated 23/5/2006, said road was upgraded to district main road. Now, this is also a document to which I have no access. They have not given me that document also. Then, my lord, they refer to their proceedings and they proceed as though this is correct. At the bottom, lord, of page 43, thus the crusher safe zone should not be within 100-meter radius from the district main road under 6(1)(b). In the joint inspection of 27/10/21 submitted with the revenue and the officials of so-and-so in respect of land measuring 117/2 2 acres, informed that the said crusher unit is approximately 35 meters distance from the district main road to Pandavapura. In the letter submitted by executive engineer, dated so-and-so, informed that Pandavapura road leading from Pandavapura road to so-and-so, as per government order of 11/5/2006, was upgraded to district main road. So it's not something which is new. It happened in 2006, 10 years before my measurement was done and license was given to me. So this is nothing new, madam. Then at the bottom of page 44, my lord, I refer to and rely upon the earlier measurement. The applicant filed an application dated 15/5/17 seeking for grant of permission to crusher unit in respect of Patta land bearing survey number 117/2, measuring 2 acres. The said application applied area is 102 meters away from the district main road. Said report submitted by earlier Revenue, Forest Department, Geology, Karnataka Pollution Board on conduct of joint spot inspection as per the same, in terms of the decision taken in the meeting of the district regulation of so-and-so held on 8/12/17, the authority declared survey number 117/2, measuring 2 acres at Pandavapura is a crusher safe zone and issued the notification 14/12. In spite of the Pandavapura Chirkulli district main road is situated within 100-meter radius from 117/2, measuring 2 acres situated in so-and-so village. By ignoring the said point, it is noticed that a joint inspection was stating that is 102 meters away. As the said report of the said area was declared a safe zone, declaration of safe zone within 100 meters from district violation of 6(1)(b). Said section reads as follows. Then section 10 is for cancellation. For cancellation, this cannot be a ground. Only ground for cancellation is if you have violated the terms of the license. Please see section 10, cancellation, which is set out in page 45. The license issued under this act may be cancelled suo motu for reasons to be recorded in writing by the licensing authority or on considering any complaint or application filed by any person to the effect that license granted is not in accordance with the provisions of the act and rules, or that the license has violated the conditions of license. And they cancel this. The earlier measurement, my lord, is annexure my application, is annexure B. And along with that, my lord, there is a details are given at page 50. There's a sketch also. And annexure C is the one which your lordships have just now seen. The typed version is at page 54. It shows the distance. Then a formal notification is issued at annexure D, page 59. This is 14/12/17. Annexure D, not page 59.
Yes.
And please see the, after the table, my lord, at page 60, approval has been given in the meeting to declare the aforesaid 10 acres as safe zone for establishing stone crusher unit. This notification issued subject to conditions to follow conditions imposed under the Act. Then license is given to me, annexure E. At page 61, declaration 62 is the license fee.
Yes.
Then the show cause notices are there, my lord. Just kindly see, my lord. Now the variation in the stand. Page 64, annexure G, second para, they say, now this 35 meters is nowhere there. Suddenly they come up with 73 meters. Second para, my lord, of page 64. On verification of the crusher area by technical team of this office on 8/3/21 and submitted report stating that your crusher area is situated 73 meters distance from the district main road. From 2019 till 21, nothing happened. Then, my lord, so many notices, inspection. And finally, my lord, page 110 is the second inspection which your lordships have already perused. Your lordships may only notice one thing, my lord, at page 110. At the bottom of that columns there, which are there, my lord. Section 6 conditions in bold letter is there, my lord. Not to establish within 100 meters from major district road, 50 meters from other roads. And the next column is 35 meters distance from major district road. Which is that district road? They should have mentioned it. They have not mentioned. Whereas in the earlier inspection, that is clearly mentioned as to which road they were measuring. Your lordships could compare page 54 and 110. It will become very clear. This is a got up report. The penultimate column in page 54 says distance from which road they're specifically in mentioning. Whereas that is not there here, conspicuously absent. When they measured it, it was not with notice to me. I was not present. And from which point they measured it, not clear. There's no map also attached to it. There's no sketch attached to it.
Yes.
My lord, please see section 10.
It is
Their deemed extension, they have themselves admitted it, my lord. The section, my lord, is 5 subsection 2. This is post the 2020 amendment, my lord. It says, subject to payment of annual regulation fee, all existing crusher licenses granted before the commencement of the 2020 Act shall be deemed to have been granted for a period of 20 years from the date of original grant and shall be extended accordingly. So it's operational automatically. So I would be entitled not from 2019 for 20 years, which should be 2029 to 2039. This is so far as this writ petition is concerned. No? The other writ petition, my lord, became necessary though in the notice, they say I'm entitled to automatic extension. They're not giving it to me. So in WP 4010, my prayer, my lord, is that I am entitled to 20-year lease. And the prayer, my lord, is at page 18, begins at the bottom, call for records. At 19, issue an order in the nature of mandamus directing respondents 1 and 2 to pass an order treating Form C license dated 2/2/19 granted to petitioner is deemed to have been granted for a period of 20 years under subsection 2 of section 5 as amended by Act 28 of 20. It's only operational. Now they don't want to give me the benefit of that on the ground that the license has been cancelled. Our representation in this regard, my lord, is at page 75, which was the cause of action for this writ petition, page 75, annexure N. 11th September 23. I am the absolute owner of the property bearing number so and so. As absolute owner, I had made an application for grant of Form C. Various authorities after inspection submitted report inter-alia stating that the area applied for by me is more than 100 meters from various roads. Accordingly, on 14/12/17, notifications issued declaring scheduled property a safe zone. Form B1 was issued on 26/12/17. After obtaining consent for operations, Form C was issued to me on 2/2/19. They have not granted it. The contempt, my lord, arises because they did not comply with this. And there, my lord, there is a compliance requirement which they have to give, which is there is an integrated lease management system, my lord, which is under their control. That they are not activating. So that was a complaint which we had made to say in spite of the interim orders, they have not complied with it. It's clear. Wait.
My lord, section 10 may be seen for a minute, my lord. Karnataka Regulation of Stone Crushers Act.
Section 10.
Yes, yes, my lord.
Cancellation of license. Yes.
My lord, it can be cancelled under 3 circumstances, my lord. The license issued under this act, my lord, may I? Three circumstances, my lord. First, my lord may see the license issued under this act may be cancelled suo moto for the reasons to be recorded in writing by the licensing authority, or on considering any complaint or an application filed by any person to the effect that the license granted is not in accordance with law with the provisions of this act and rules, or that the licensee has violated the conditions of license. Now, my submissions to my lord is, my lord, this has been done by the authority for the reason, my lord, that there is a violation of, my lord, the provision of the act. If my lord could just blank out, my lord, this, my lord, if my lord could just read it like this: the license issued under this act may be cancelled suo moto for the reasons to be recorded in writing by the licensing authority, my lord, to the effect that the license granted is not in accordance with the provisions of the act. My lord, here it is not in accordance with the provisions of the act is for the simple reason, my lord, that it is within 100 meters, my lord, from the major district road. So the licensing authority can suo moto, my lord, initiate action for cancellation of the license.
Anything else? That is all right, but then where is the prescription for remeasurement?
Very well, then if it is for if my lord is this thing for remeasurement, then I have no.
Now you point out that what is the basis of your submission? We are not deciding anything, only considering.
My lord, since this road was upgraded.
Before?
No, it was upgraded. My lord, it was, no, it was upgraded later. That is the reason why, my lord, they found that it came within the 100 meters.
Upgraded after expiry?
Yes. My lord, in my statement of objections also, I have explained, my lord may please see. My lord, my first defense is with regard to section 15, saying that it is appealable. Then my lord may take from paragraph 6 onwards. And then I leave it to my lord because I don't want to unnecessarily this thing. My lord, it is pertinent, may I read, my lord? It is pertinent to mention here that for the declaration.
One second, page?
My lord, my statement of objection, my lord, internal page 3, it pertains to maintainability, my lord. That is, an appeal can be filed under section 15, my lord, to the regional commissioner of the Stone Crushers Act.
Yes.
My lord, then paragraph 6, I have, from paragraph 6 onwards, I have explained to my lord. It is pertinent to mention here that for the declaration of the safer zone, the condition prescribed under subsection 1 of section 6 of the Stone Crushers Act shall be complied with. Subsection sub-rule 1 of section 6 of the Crushers Act rule is extracted here and below for ready reference. My lord, that is culled out. Then, based on the joint inspection report annexure C to the petition, a notification dated 14/12/2017 as per annexure D was issued, declaring the proposed area of the petitioner as safer zone. In the said notification, at serial number 2 is concerned to the petition. But not in the said notification, serial number 2 is concerned. In pursuance of the same, the petitioner ought to have produced consent for operation certificate issued by the Karnataka State Pollution Control Board. Upon considering the consent for operation certificate and safer zone notification, the licensing and regulation authority shall grant license in Form C. However, in the instant case, without following the procedure, the senior geologist, who is the member of the licensing and regulation authority, unilaterally issued Form C, produced at annexure F to the writ petition, which is contrary to the provision of the Stone Crushers Act. The Act contemplates that the license shall be issued to the District Stone Crusher Licensing and Regulation Authority constituted under Section 8 of the Crushers Act. As such, issuance of the license in Form C itself was void ab initio. Be that as it may, while considering joint inspection as per annexure C, the concerned official / authorities have not noticed the major district road near the applied area of the petitioner, that is Pandavapura Chinnakurli district road, situated within the radius of 100 meters from survey number 117/2, measuring 2 acres of Alpahalli, Pandavapura Taluk. The technical advisor of the Department of Mines and Geology conducted spot inspection on A321 and reported that the declared safer zone in survey number 117 is within 73-meter radius of the major district road. As such, the said report was submitted to the licensing authority, and in the meeting of the licensing authority dated 16/4/2021, the issue pertaining to the declaration of safer zone, though major district road, Pandavapura Chinnakurli district road, is situated within 73 meters from declared safer zone in survey number 117. Accordingly, in the meeting, it was resolved to issue show cause notice to show cause as to why the license issued in favor of the petitioner should not be cancelled. It is submitted that in pursuance of the meeting of the licensing authority dated 16/4/21, the member secretary stroke senior geologist issued a show cause notice dated 23/4/21, calling upon the petitioner to show cause as to why the license should not be cancelled as per Annexure G to the petition. It is submitted that it was brought to the notice of the licensing authority in the meeting held on 26/6/21 that the senior geologist stroke member secretary of licensing authority issued license in Form C in favor of the petitioner unilaterally without there being a decision of the licensing authority agreeing grant of license. In this regard, the licensing authority directed the member secretary to issue show cause notice to the petitioner. Accordingly, a notice dated 20th July 2021 was issued to the petitioner, copy of which is produced as Annexure R1 to this statement of objections. It is submitted that the petitioner submitted a reply to the notice dated 23/4/2021 on 6/5/2021. In the said reply, the petitioner contended that on 19/10/2020, there was a correction to the distance of the road, and the same was fixed at 50 meters, and inspection was done in the absence of the petitioner. As such, requested to consider the case of the petitioner, and the petitioner also filed a reply to the notice dated 20th July 2021 on 23/7/2021, which is produced as Annexure R2. My Lord, it is submitted that in the meeting of the licensing authority dated 28/7/2021, the case of the petitioner was discussed at length and decided to cancel the license issued in favor of the petitioner exercising power under Section 10 of the Crushers Act. It is submitted, my Lord, that I will skip. My Lord, in paragraph 12. My Lord, it is submitted that the Assistant Executive Engineer, PWD number 7 subdivision, Pandavapura, by letter dated, my Lord, by letter dated 18/10/2021, informed that in Pandavapura Taluk, the road leading from Pandavapura to Chinna Kurali, my Lord, as per government order dated 11/5/2006 and 23/5/2006 was upgraded as a district main road. My Lord, copies of those letters I have produced as Annexure R5. My Lord, it is submitted that the licensing authority in the meeting dated 31/3/2022, considering the oral and written submissions made on behalf of the petitioner, joint inspection report, photographs, and the provisions of the Karnataka Stone Crushers Act 2011, passed a detailed order and resolved to cancel the license issued in Form C under Section 10 of the Stone Crushers Act, and further resolved to cancel the declaration of safer zone and directed the petitioner to clear all machineries installed at survey number 117/2 measuring 2 acres. My Lord, the petitioner has placed reliance on the reported judgment of this Honorable Court in WP 734 of 2020 in the case of H.T. Manju versus State of Karnataka, decided on 17/1/2020. It is respectfully submitted that the said judgment is inapplicable to the facts and circumstances of the case. In the said case, a notice was issued calling upon the petitioner to shift the crushing unit, placing reliance on Clause B of subsection 1 of Section 6 of the Act 2011 on the ground that the site of the crusher unit is within 100 meters from major district road. The Honorable Division Bench, after adverting to the contentions of the party, held that the petitioner cannot be prevented from carrying on the activities on the basis of the license granted so long as the same is in subsistence. Accordingly, the division bench was pleased to set aside the impugned order stroke notice on the ground that the respondents have no power to issue such notice order. Whereas in the present case, the licensing authority, upon granting opportunity to the petitioner of being heard by exercising power under Section 10 of the Crusher Act 2011, passed the impugned order. My Lord, then Section 10 has been extracted. My Lord, for a minute, my Lord may take. My Lord, the order passed, my Lord, by the coordinate bench of this Honorable Court, my Lord, which is produced. My Lord, which is produced as Annexure J to the writ petition, my Lord, page 69. While considering, my Lord, a similar case, my Lord may take paragraph 6, page 72.
Same 9037.
My Lord, yes, my Lord, it is, yes, my Lord, 9037 of 2022. My lord, the order is at page 69. Page, my lord, paragraph 6, the fourth sentence. Page 72. My lord gets it, my lord. My lord, fourth sentence, perhaps. Fourth sentence. Perhaps if according to the respondents, my lord gets it. Fourth sentence, my lord, in paragraph 6.
Moreover.
Perhaps if according to.
Yes.
My lord, perhaps if according to the respondents, the license granted to the petitioner is not in accordance with the provisions of the Act of 2011 or rules framed thereunder, possibly the power under Section 10 of the Act 2011 can be invoked for cancellation of the license, but that also after giving an opportunity of being heard to the license. With the license being cancelled, my lord, Form C is not in currency, hence the question of the question of extending it for another period of 20 years doesn't arise. And taking all the measurements, my lord, 73, 36, 19, they are all within 100 meters. That's all my submissions.
Now, you spoke about alternative remedy.
Yes.
Alternative remedy only if the license were to be valid. The prior remedy is further enhance it for a period of 20 years. From
My
the
lord,
date
that
of,
doesn't arise for the simple reason, my lord.
now that cannot be paid in the alternative remedy.
No, it's all right.
That prayer cannot be made in the alternative remedy. What has been prayed over here. Next, in your objections, you have not stated what is the actual measurement. There are 3 measurements as per your own records.
Yes.
One is 130 meters, another one is 75 meters, another one is 35 meters. As per government documents,
Yes, my lord.
there are 3 measurements. One is 130 meters. That was while granting him the sanction.
Yes.
Next, after cancellation, it becomes 75. Then thereafter, it becomes 35.
My lord, for that I submitted to my lord from paragraph 6, how it came to be issued. The form, my lord, Form C, I have explained how Form C came to be issued. That is all that I can submit.
Now, this variation
Yes.
is simply not acceptable. You can't justify it also. The error, if it is, say 1 meter, 2 meters, it's understandable. Where is 130 meter and where is 135 meters?
My lord, because of the upgradation, my lord.
Even upgradation, what is the extent of road that has been upgraded? Because measurement is always from the center of the road.
Yes.
Measurement is not from the side of the road.
Yes.
Correct?
Yes.
It is from the
middle of the road.
Middle of the road. The middle of the road will always be same, whether it's upgraded or not. Whether it's a village road or a district road or a national highway, unless you shift the road somewhere.
Yes.
That is not your contention. And then the third aspect remains, if that is the variations in your measurement, it speaks very poorly about your officers. Now, what action have you initiated against your officers?
My lord, after this, I'll have to write to the government to initiate.
No, it has to be no, madam, because see, this is an area where the general perception is people are harassed by officers for various things.
No doubt about that. But
Yeah. So when that is the case, when such a variation is there, from your officers, what action you have initiated against your officers. It becomes a very relevant question.
My lord, but the fact remains, can Rule 6(1)(b)
And then
be violated?
it's private property. It's a patta land, right? It's not a government,
Right.
it's not a
But
government
the
land.
fact that license is given for establishment of a stone crusher, and if it is, my lord, within 100 meters, can Rule 6(1)(b) be overlooked? And that is the reason why I read, my lord, section 10 also, where I said that even the my
See,
lord,
nothing
the
can be
authority.
overlooked over here. The legal provisions definitely cannot be overlooked. But the point is, what is involved over here is as a factual dispute.
No, that is true.
The
That is the
factual
reason.
dispute as to where the site is located. The distance of the site from the road. That had to be clarified unequally by the respondents, the state. Now, how do you justify this 130 meters, 75 meters and 35 meters?
My lord, to overcome that only I made a suggestion, my lord. To overcome that, I made the suggestion. Though I couldn't say it openly.
Reserve it, we'll reserve it.
May I just take 2 minutes, my lord? My learned friend read from the statement of objections, number of points, my lord, that committee did not meet, this, that and all. My lord, in the show cause notice, there is no reference to that, my lord, in the first show cause notice. They only say on measurement. Says beyond distance. All these other issues are not raised. In the my learned friend's contention was that this license was issued without that authority properly considering it. That's not there. In the second show cause notice, they tried to raise it. I filed a reply, but the order doesn't say anything. You know, the order is not on the basis that the original license was fraudulently issued or illegally issued. That's not the point at all. So all these other submission would have no bearing, is my respectful submission.
My lord, for a minute, my lord, I forgot to read, my lord, section 5.
We are reserving.
My lord,
Only
that
one
troubles my lord.
explanation, or section 6 contains an explanation. My learned friend said road is this, that and all. The explanation reads like this, not to section 6. For the purpose of this act, any habitation, school, temples or road coming up subsequent to the declaration of safer zone shall not affect the operation or continuance of such declaration and shall not affect the extension of license. So, my lord, today the road is here and this declared a safe area. Suppose the road is shifted here, it becomes closer. Explanation says it shall not affect. So, their entire argument, my lord, is covered by explanation also. Section 6, explanation of the act. Section 6. There are 3 subsections. After the 3 subsections, that explanation is there. So if it was good in 17, it'll continue to be good in later also, even if there's a change. Suppose a school comes up next door. Explanation at the end of 6(3). There's a proviso after the proviso.
I have produced an extra R5 to my statement of objections, my lord, wherein my lord, the upgrading of the road is given as 17/9/2007.
So it says that original declaration will stand, notwithstanding the changes in terms of habitation, school, temples, or road coming up subsequently.
My lord, this is not subsequent. This is earlier.
Earlier.
My lord, an extra R5. That's the reason why I was showing an extra R5 file to the statement of objections.
And then they are better off.
Absolutely. That's my submission.
Your case is you had measured it wrongly initially.
Even
Your
that they
case is
don't
you had
say.
measured it wrongly initially.
That they don't say.
Oh, I've said it. In my statement of objections, I've said it.
It was a mistake, that's what.
My lord, the definition of, my lord, term of license may be seen, my lord, section 5. For a minute. Section 5. My lord, the license shall be valid for 20 years and may be renewed for a further period of 10 years, subject to fulfillment of the conditions laid down under this act or the rules made thereunder. This was conveniently not read.
No allegation of violation.
So 20 years and a further period of 10 years.
This has been cancelled because of violation of Rule 61B. And I've stated my statement of objections also that Form C could not have been issued.
We'll see.
Obliged me.
It's in 99.1. I've been filed a withdrawal, your lordships. I may permitted to withdraw the contempt in 99.1.
Learned 99, learned revocated Mr. So 6 permission to withdraw the contempt petition. Petition is dismissed to withdraw. Number 99.1.
Interim orders may kindly be continued in our case. Wait.
Pardon?
Lord, the next matter, 100.
Today, we have some other.
No, this next,
Yes.
it has become infructuous.
Which
The next matter, PIL, it was about some under construction work blocking the road. We have finished the construction work, Lord, I am filing an affidavit and photograph to that effect. We have completed the construction, so therefore the list does not survive any further.
serial number?
100, very next matter, 100, item number 100. I'm filing a very short affidavit to bring on record that the work has been completed. I'm also producing some photographs to show that the construction work is completed totally.
Day after tomorrow?
Thursday, my lord, Thursday.
Thursday, Thursday at 2:30.
Serial number 52, my lord, serial number 52. Last occasion, my lord, your lordship directed to complete the orders within 11th of this month, my lord. Till today, they have not, my lord, it is listed today. They have not complied, my lord. The direction issued by the. Kindly. Tomorrow, my lord.
It was mentioned in the morning. Regarding my lord's withdrawal of the criminal cases with the government. Section 321, my lords, I know that the lordship, my Thursday. Because they have already withdrawn, 5 cases are closed by 2-line order by the learned judicial magistrate. And my lord, serious cases, applications are filed.
Day after tomorrow,
Thursday.
Thursday.
Tomorrow.
Number 69.
Sorry.
My matter, my lord,
Tomorrow,
52.
Election matter is there. One more day accommodation.
52 is, my lord, day after tomorrow, my lord.
Thursday.
Serial number 52 is the day after tomorrow, my lord. Because, my lord, there is a positive direction to restore my name in the revenue record, madam. Last occasion, your lordship directed to pass the orders, my lord. Till today, they have not passed, my lord. Tahsildar. Day after tomorrow.
No, 17th April.
Serial number 44.
Serial number 69, we had to file memo of it.